Asep Saifuddin Jahar, the Faculty of Sharia and Law, UIN Jakarta, Professor Dr. Mashpuri Abdullah, Sharia and Law Faculty, UIN Jakarta, Professor Timothy Lindsey, the University of Melbourne, Australia, Professor Christian Lange, Utrecht University, Netherlands, Professor Najma Musa, University of the Western Cape, South Africa, respectable Vice Dean of Academic Affairs, Dr. Sahrul Adam MAG, Vice Dean of Administration Affairs, Dr. Muhammad Maksum MA MDC, Vice Dean of Student and Cooperation Affairs, Dr. Haja Maskufa MAG, Head and Secretary Study Program. Distinguished guests and participant and presenter, ladies and gentlemen, good morning. A very warm greetings to each and every one of you. Welcome to the 6th International Conference on Law and Justice, Iclj. The Faculty of Sharia and Law, Sharif Hidayatullah State Islamic University, Jakarta, in collaboration with the Faculty of Sharia, Mataram State Islamic University, which has themed Sharia toward the digital world, breakthroughs in the fields of law, justice, and human rights in Smart Society 5.0. Today, Monday, 29 of August 2020 in Sheraton Hotel Sanggigi, Lombok, West Nusa Tenggara. I'm Dr. Masrofa, the Master of Ceremony for this event. On behalf of the organizing committee, we extend our appreciation of your presence today. First of all, let's ask thanks to Allah subhanahu wa ta'ala, who has been giving us mercy, guidance, happiness, and healthy, so we can attend and participate in this event without any obstacle until now. Praise and salutation upon to our Prophet, Muhammad sallallahu alaihi wasallam, the last messenger, the best figure of this universe. Ladies and gentlemen, let's begin this opening session by saying Basmalah. Bismillahirrahmanirrahim. Quran recitation by Dr. Nur Hassana MAG.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. لله ما في السماوات والأرض. إن الله هو الغني الحميد. ولو أن والبحر يمده من بعده سبعة أبحر ما نفدت كلمات الله ما نفدت كلمات الله إن الله عزيز حكيم ما خلقكم ولا بعثكم إلا كنفس واحدة ما خلقكم ولا بعثكم إلا كنفس واحدة إن الله سميع بصير صدق الله العظيم والسلام عليكم ورحمة الله وبركاته.
Thank you to Dr. Nur Hassan MAG who has recited the Quran. May Allah bless us. Amin ya Rabbal Alamin. The national anthem of Indonesia Raya will be led by Sri Hidayati MAG. The audience requested to stand up. Indonesia Raya will be led by Sri Hidayati MAG. The audience requested to stand up. to sit back. Thanks to Mrs. Tridayati MAG as the conductor of National Anthem Indonesia Raya. Prayer will be led by Dr. Haji Nahrawi SMH.
Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin. Allahumma salli wa sallim ala Sayyidina Muhammadin wa ala alihi wa ashabi ajmain. Allahumma gfir lana wa liwalidina wa li asatidina wa li jami'il muslimina wal muslimat wal mu'minina wal mu'minat ya rabbal alamin. Allahumma ja'al jam'ana hadha jam'an marhuma wa tafarruqana min ba'dihi tafarruqan ma'suma. Allahumma iftah qulubana futuhal arifin. Allahumma iftah alaina hikmataka wansur alaina min hazaini rahmatik. Allahumma rabbana taqabbal minna du'aana innaka antas sami'ul alim wa tub alaina innaka antat tawwabur rahim. Ya Allah, ya Rabbal alamin, Tuhan yang Maha Pengasih, yang kasih-Nya tiada pernah pilih kasih. Tuhan yang Maha Penyayang, yang sayang-Nya tiada berbilang. Tuhan yang Maha Kuasa, yang kuasanya di atas raja-raja. Jadikanlah acara The International Conference on Law and Justice yang ke-6 yang diselenggarakan oleh Fakultas Syariah dan Hukum UIN Syarif Hidayatullah Jakarta bekerja sama dengan Fakultas Syariah UIN Mataram menjadi acara yang engkau ridhoi, menjadi acara yang engkau berkahi, yang hasilnya membawa kemaslahatan bagi kami, membawa kemaslahatan bagi negara kami Indonesia, membawa kemaslahatan bagi negara-negara di dunia. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar. Walhamdulillahi rabbil alamin. Assalamualaikum warahmatullahi wabarakatuh.
Thanks to Dr. Haji Nahrawi SMH who has led the prayer. We hope this conference will run well without any obstacle at all. Ladies and gentlemen, we hereby invite the Rector of Syarif Hidayatullah State Islamic University Jakarta to deliver her welcoming speech and open the 6th International Conference on Law and Justice officially. Professor Dr. Haja Ahmani Lubis LCMA, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah wassalatu wassalamu ala Rasulillah, amma ba'd. Honorable Chief Justice of Constitutional Court of the Republic of Indonesia, Bapak Dr. Wahiduddin Adams, respectful Dean of Faculty of Sharia and Law, Professor Dr. Ahmad Tolabi Kharli, Honorable Professor Dr. Mashpuri Abdullah, the advisor, advisor, pardon? Special advisor to the Vice President of the Republic of Indonesia. Yes, and Honorable Vice Deans, heads of departments, speakers, keynote speaker, and also researchers of this conference. First of all, I would like to welcome you in this international conference, the 6th International Conference on Law and Justice, or it's abbreviated as ICLJ. Yes, and the theme of this year is Sharia towards the digital world, breakthrough in the fields of law, justice, human rights in smart society 5.0. Yeah, we are happy to have you all here from inside Indonesia and also some speakers from abroad. And we hope that we will have a very good deliberation about the theme of the conference, inshallah. In this precious opportunity, I would like to talk about the role of Islamic higher education in implementing smart society 5.0 era. Before discussing the university's role, our university, Sharif Hidayatullah State Islamic University, role in implementing smart society 5.0, I'd like to talk about the definition or the elaboration of what's the concept of society 5.0 at a glance. Society 5.0 was launched by Japan in its 5th Science and Technology Basic Plan 2016 till 2020. Following the hunting society, it's the society 1.0. And then the agricultural society, it's called by society 2.0. And then this the industrial society means society 3.0. And the information society, society 4.0. And the smart society, it's society 5.0. And this last society, means society 5.0, aims to stimulating science, technology, and innovation, or STI, to achieve a prosperous, sustainable, and inclusive future. Society 5.0 counts not only on STI, but also the human beings as a critical element to its success. The role of Islamic higher education, such as in our university, Sharif Hidayatullah State Islamic University, in this regard is very crucial because it prepares the young generation to enter smart society 5.0 as the former develop basic skills such as critical thinking, problem solving, innovation, and creativity. Similarly, apart from a family at university, in its institution where students are taught to be good people and able to solve problems. In our university, as we understand, the lecturers are not responsible for transferring the knowledge, but also, moreover, for educating students and what's good and what's not good, what's proper and what is not. So it's also about transferring the norms and the values. Ladies and gentlemen, as I said before, that before entering Smart Society 5.0 era, we are in the era of information society, Society 4.0. In fact, we don't fully live the information society 4.0 era. Science and technology and information are still crucial in the Smart Society 5.0. In this context, the higher education, the COVID-19 pandemic is a blessing in disguise, as the teaching methods are more creative and richer. As the pandemic prevents us from having offline meetings, that's why a lecturer is forced to find other ways to deliver the course, mainly through the help of Google Meet, Zoom Clouds, and other platforms. Some lecturers create YouTube channels and disseminate their lessons and ideas through these platforms. These methods might never have been thought before by many people. However, we should notice that information society 4.0 in academia is not only about the teaching methods, it's more complex than that. At the global level, local levels, the law is a powerful tool for advancing the right to health and addressing public health, emergencies. As we know, our university during these last 2.5 years, we face a very active situation in dealing with the COVID-19 pandemic. We help the sick and also help the students for having their support to study in our university. And also, moreover, in this coming Smart Society 5.0, strong legal capacity is needed to support the effective national and international responses to justice and human rights. So we are about at the end of the pandemic, but we still need the legal capacity to make stronger our society and to protect the society and to make the national development easier for everyone, inshallah. As a rector, I'm optimistic that our university can lead in the 5.0 Smart Society era. One of the reasons is that our university is fully helped or supported by the IT system, and also the lecturers and the students are used to use this IT means, so that we can face the 5.0 Smart Society era, inshallah. There are 3 students who achieved last year awards. Yeah, one of whom is Ade Rianto from Department of Family Law Faculty. Yeah, from Department of Family Law, Sharia and Law Faculty. He won the first prize of Smart IT Fest Quantum 2021, which was, which was held by Universitas 11 Maret. Ade Rianto and 2 others of our students from Faculty of Science and Technology and Faculty of Dirasat Islamiyah have developed a startup Nikahpedia, an application directed to who plan to marry. The main features are marriage law, testament, consultation on marriage, etc. Our students' ideas are brilliant as they combine technology and knowledge of marriage law or marital law that our society can use. So this is just one of the examples that our students use IT to make innovation in their fields. Ladies and gentlemen, the Faculty of Sharia and Law itself is a source of 5.0 smart society. We are convinced that Sharia is still relevant and can resolve problems in our community. Obviously, in the context of Indonesia, Sharia position is important. Some aspects of Sharia have become national law. The several other aspects have also inspired our national law. In Sharia, we understand that what is called by Maqasid Sharia is purposes and principles of Sharia. Traditional Islamic jurists have agreed on 5 purposes of the Sharia. And Sheikh Yusuf Al-Qaradawi give an example that there is universal maqasid or universal purposes of the law, and it's include preserving true faith, preserving human dignity and rights, calling people to worship God, purifying the soul, restoring moral values, building good families, treating women fairly, building a strong Islamic nation, and calling for a cooperative world. And I would like to add also from the thought of Sheikh Abdullah bin Bayya. He's now in Abu Dhabi, the United Arab Emirates. He add to this maqasid as the concept of nation building and the citizenship. So one of the purposes also for the Islamic law is a citizenship. So we should develop and we should build our nation, our country. It's a must and it's the purpose of Sharia. Yeah, I think that we all agree that we should love our country and also make all the efforts to make the people make the people prosperous and peaceful. Yeah, inshallah. So this is how we frame things and how we try to solve the problems faced in the world. Science and religion do not contradict one another. On the contrary, it can strengthen the foundation of smart society 5.0. Finally, at the end of my speech, I would like to thank all of the organizers of this conference. This is very timely to discuss the breakthrough of law in and in defending justice and human rights. And I believe that all of the speakers and participants of this international conference will have a very good deliberation. And I hope out of this conference, there will be very good also insight and recommendations for our university, for our government, and also for the world, that we can build the world in a better way in the future, inshallah. So thank you very much again. and I'm happy to be here in Lombok with you all, and I hope you also enjoy your time in Lombok. And for the international speakers, we would like to have you in the next conference, inshallah, in Indonesia. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thanks to Professor Dr. Haja Amani Lubis LCMA, who just officially opened the 6th International Conference on Law and Justice. May Allah bless our international conference. Amen. Distinguished guests and participants of this Iclj, the ceremonial of hitting the gong to start the event. I would like to invite Director of YN Jakarta, Director of YN Mataram, and the Chief of National Court of Republic Indonesia, Dr. Hudin Adams, the Dean of Sharia Law Faculty, Professor Dr. Abdullah to come forward to hit the gong. And the gong will be hit, the first one by Rector YN Jakarta, and the second one by the Rector of YN Mataram. I would like also invite Professor Mashpuri Abdullah to come forward to the stage. Ladies and gentlemen, this is the 6th International Conference on Law and Justice 2022. I would like to invite the Vice Dean of Sharia Law Faculty, Ladies and gentlemen, honorable speakers and participants, this is the end of the opening ceremony of the 6th International Conference on Law and Justice, Iclj, the Faculty of Sharia Law in Jakarta, in collaboration with the Faculty of Sharia, Mataram State Islamic University, with HESTEAM Sharia Toward the Digital World, Breakthroughs in the Field of Law, Justice, and Human Rights in Smart Society 5.0. And the conference will be held The conference will be held from 28 until 30 of August 2020 in Sheraton Hotel Senggigi, Lombok, West Nusa Tenggara. For your information, after this opening ceremony, there will be keynote speech, the first from Dr. Wahidun Adams, SIMA, the Chief of Justice of the Constitutional Court of Republic Indonesia, and also the invited speaker too from Professor Dr. Mashpuri Abdullah, the Faculty of Sharia and Law, Jakarta. And there will be invited speaker 3 from Professor Dr. Asep Saifuddin Jahar from UIN Jakarta. And the next one, there will be invited speaker 3 from Professor Timothy Lindsey from the University of Melbourne, Australia. And next, there will be invited speaker from Professor Christian Lange from Utrecht University, Netherlands. And next, there will be invited speaker from Professor Najma Musa, University of the Western Cape, South Africa. Ladies and gentlemen, that's the end of this opening session. Let's end this opening session by saying Hamdalah. Alhamdulillahirabbil alamin. Thank you for your presence, participation, and attention. Wassalamualaikum warahmatullahi wabarakatuh. And the next keynote speech by Dr. Wahidudin Adams, SIMR, the Chief Justice of the Constitutional Court of Republic Indonesia, will be led by the moderator, Nur Hidayah, PhD.
Honorable Rector Win Syarif Hidayatullah Jakarta, Honorable the Dean of the Faculty of Sharia and Law, Win Syarif Hidayatullah Jakarta, distinguished keynote speaker and invited speaker of the conference, International Conference on Law and Justice, and the participants, both offline and online digital platform. We will come to the first session of the keynote speech, and then the first keynote speech will be delivered by Dr. Wahidudin Adam SHMA, the Justice of the Constitutional Court of the Republic of Indonesia. Before that, I would like to read the brief CV of Dr. Wahidudin Adams, born in Pulau Gebantu, Hilir, 17 January 1954, and currently he is the Chief Justice of the Constitutional Court of the Republic of Indonesia, and he graduated from the Faculty of Sharia and Law, Win Syarif Hidayatullah Jakarta, and also from the University of Muhammadiyah Jakarta, and also Master of Sharia Law from Win Syarif Hidayatullah Jakarta, and Doctor from the Win Syarif Hidayatullah Jakarta, and also he continued the postdoctoral cursus Westvager in Leiden, the Netherlands in 1987. He is actually the career judge in the Constitutional Court, and also from the Supreme Court, and also he is also the lecturer at the Faculty of Sharia and Law, Win Syarif Hidayatullah Jakarta, and Faculty of Law, Universitas Muhammadiyah Jakarta, and also he is also the considered board of the Majelis Ulama Indonesia. So without further ado, I would like to invite Dr. Wahidudin Adam for delivering the keynote speech of the International Conference on Law and Justice. Pak Wahidudin Adam, time is yours. Ladies and gentlemen, please accept Dr. Wahiduddin Adam would like to deliver this keynote speech in Indonesia.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. Wa bihi nasta'inu ala murid dunya waddin. Wassalatu wassalamu ala sayyidina Muhammad sayyidil mursalin wa ala alihi wa ashabihi ajmain, amma ba'd. Yang saya hormati Rektor Universitas Islam Negeri Syarif Hidayatullah Jakarta, Ibu Profesor Dr. Hajjah Amani Burhanuddin Umar Lubis LCMA, Dekan Fakultas Syariah dan Hukum Universitas Islam Negeri Syarif Hidayatullah Jakarta, Bapak Profesor Dr. Haji Ahmad Tolabi Karli, SAG, SH, MH, MA, para pembicara, speakers, pembahas, researchers, moderators, dan peserta, participants, serta para hadirin rahimakumullah. Puji syukur kehadirat Allah Subhanahu wa taala karena hanya atas izin dan karunia-Nya kita dapat berkumpul dalam forum ilmiah yang sangat membanggakan ini, yakni International Conference on Law and Justice yang ke-6 yang diselenggarakan oleh Fakultas Syariah dan Hukum Universitas Islam Negeri Syarif Hidayatullah Jakarta di Lombok, Nusa Tenggara Barat, Indonesia, tanggal 28 sampai dengan 30 Agustus 2022. Suatu konferensi internasional dimanapun dan kapanpun akan selalu dinanti oleh para akademisi, kaum intelektual dan masyarakat luas guna menghasilkan suatu pertukaran hasil analisis, pemikiran, dan pengayaan multi perspektif terkait tema yang disepakati dan atau yang ditentukan. Apabila dibandingkan dengan seorang hakim seperti saya sekarang ini, para akademisi dan kaum intelektual tentu memiliki suatu keistimewaan dan kemewahan, privilege berupa academic freedom untuk dapat menganalisis tema hukum tertentu dan mungkin juga di dalamnya termasuk putusan pengadilan serta dissenting opinion dan concurring opinion hakim. Oleh karena itu, hasil nyata dari pertukaran pemikiran dan pengayaan multi perspektif atas tema dan konferensi internasional semacam ini sangatlah diharapkan oleh berbagai pihak. Tidak terkecuali saya sebagai seorang hakim, guna menghasilkan suatu perubahan dan produk hukum yang lebih baik. Dalam kesempatan ini, penyelenggara memilih tema tantangan syariah dalam dunia digital dan smart society 5.0. Para hadirin yang terhormat, dalam perspektif perbandingan hukum global, syariah merupakan salah satu keluarga hukum, legal families, yang telah lama mempengaruhi perkembangan hukum global sejak ribuan tahun yang lalu, sebagaimana juga antara lain keluarga hukum kanonik, hukum Romawi, Romance Germanic Law, hukum Anglo-American, hukum Skandinavia, Nordic Law, serta Timur Asing, Far East Law. Kriteria klasifikasi terhadap berbagai keluarga hukum ini umumnya dilakukan antara lain berdasarkan bahasa yang digunakan, language usage, teritorial keberlakuannya, jurisdiction-nya, serta filosofi, esensi, dan nilai-nilai filosofi, essence and values yang terkandung di balik norma, teks atau nasnya. Khusus mengenai syariah, hingga saat ini masih sering ditemukan berbagai kesalahpahaman hingga stigma yang keliru. Syariah tidak jarang direduksi sehingga seolah-olah muncul kesan bahwa syariah merupakan suatu tradisi dan bentuk hukum yang usang dan boleh jadi dinilai tidak ramah pada jaminan hak asasi manusia, human rights. Padahal filosofi, esensi dan nilai-nilai syariah apabila dipahami dengan tepat justru merupakan hukum yang tak lekang dimakan zaman, sehingga sekaligus senantiasa mampu bersifat adaptif sesuai dengan kondisi wilayah dan kemasyarakatannya. Solihun likuliz zaman wal makan. Sebab sebagaimana pendapat Wahbah Az-Zuhaili, pakar fikih abad ke-21, terkenal beberapa karangannya, kitab Tafsir Al-Munir, fikih. Syariah pada hakikatnya memiliki sifat keteraturan dan komprehensivitas sesuai dengan fitrah manusia, serta senantiasa mengutamakan keadilan dan kemaslahatan. Para hadirin yang terhormat, dalam kamus Merriam-Webster, syariah secara etimologis dan konseptual dimaknai sebagai bentuk hukum yang secara transendental bersumber dari firman Allah Subhanahu wa taala dalam kitab suci Al-Qur'an yang kemudian dilengkapi dengan hadis sunnah Rasulullah Muhammad sallallahu alaihi wasallam, dan secara teoretik tidak hanya mengatur akidah tetapi juga meliputi muamalah seperti politik, ekonomi, sosial, hukum pidana dan etika, hingga mengatur soal-soal pula yang bersifat private apabila dipahami secara keliru, sehingga seringkali dianggap sebagai hal yang sederhana seperti perkawinan, rumah tangga, waris, hingga tata cara makan dan masuk ke toilet. Jika dikaitkan dengan tema konferensi internasional ini, maka syariah dimunculkan dalam dimensi muamalah, khususnya tawaran konsep syariah bagi manusia dalam menyikapi fenomena disrupsi digital menuju abad global, smart society di era 5.0. Disrupsi secara sederhana dimaknai sebagai suatu perubahan dalam arti yang sangat spesifik. Secara alami, by nature, selalu ada yang lahir, berkembang, berjaya, pudar, hingga akhirnya menghilang. Dan dalam beberapa hal muncul kembali dalam bentuknya yang baru. Islam secara teologis memiliki istilah dan konsep yang spesifik juga yang kita kenal dengan taghayyur. Di beberapa literatur modern ini juga sudah dipakai istilah ini, tapi ada baiknya saya dikaji ketepatan dari istilah ini nanti. Secara spesifik lagi di bidang hukum dikenal sebagai taghayyurul ahkam. Terkait dengan konsep taghayyurul ahkam ini, Al-Quran sebagai sumber utama syariah memiliki salah satu fungsi pokok sebagai pendorong lahirnya berbagai perubahan positif bagi kemaslahatan kehidupan individu dan masyarakat. Dalam menyikapi fenomena disrupsi atau sementara saya boleh izinkan guna istilah tagayur, tapi ada yang menyebut tidak sama dan istilah ini. Terdapat suatu kaidah dalam tradisi fikih populer, yakni al-muhafadzatu alal qadimis sholih wal akhzu bil jadidil aslah. Menjaga tradisi atau sesuatu yang lama tapi baik dan mengambil tradisi atau sesuatu yang baru yang lebih baik. Kaidah dan tradisi fikih ini relatif identik dengan yang disebut oleh Jepang dalam periode restorasi Meiji. Pada periode ini, Jepang melakukan suatu perubahan yang sangat fundamental dalam kehidupan sosial politiknya. Suatu perubahan yang cukup mendasar dalam sosial politiknya. Feodalisme Jepang dalam sistem dan tata kelola penguasaan serta distribusi sumber-sumber ekonomi yang telah berlangsung sejak ratusan tahun secara perlahan digantikan oleh konsep ekonomi pasar. Namun demikian, Jepang pasca restorasi Meiji ini mulai bersifat terbuka dengan konsep ekonomi barat, Western economy. Mereka tetap menjaga dan memelihara tradisi warisan leluhur, khususnya mengenai kolektivitas atau yang dikenal dengan tradisi Islam sebagai dan dalam konteks teologis sebagai konsep jamaiyah, sebagai lawan dari konsep individualistik. Seiring berjalannya waktu, tagayur yang dilakukan oleh Jepang pada periode restorasi Meiji ini telah terbukti menjadi momentum sekaligus titik berangkat atau starting point yang sangat strategis yang kemudian menjadikan Jepang sebagai salah satu negara maju, khususnya secara ekonomi, tidak hanya di benua Asia, melainkan juga di dunia. Saat Jepang memilih bersikap terbuka dalam tanda kutip pada dunia pasca restorasi Meiji, mereka semakin intensif untuk menerapkan filosofi Arabi sebagai konsep dan cara hidup untuk senantiasa memilih yang terbaik dari serangkaian alternatif dan dikotomi yang ada untuk sebagai modal penting yang dapat beradaptasi dengan perubahan zaman sebagai suatu keniscayaan. Namun tetapi juga tetap teguh menjaga penerapan filosofi awase sebagai konsep dan cara hidup yang memandang bahwa kemaslahatan manusia harus tetap menjadi tolok ukur utama dalam membuat suatu kebijakan dan kesepakatan, sehingga dalam rangka suatu pembentukan hukum, filosofi Arabi awas ini mengajarkan bahwa manusia harus senantiasa memahami setiap persoalan secara menyeluruh, secara holistik. Dalam masyarakat Jepang, filosofi Arabi awas ini diyakini sangat efektif dalam menghasilkan suatu pilihan yang terbaik terhadap beberapa alternatif yang terkadang memiliki tolok ukur yang sama, yang subhat ya, mengenai baik buruknya. Para hadirin yang berbahagia, dengan semakin pesatnya perkembangan ilmu pengetahuan dan teknologi, hidup dan kehidupan kita manusia juga mengalami disrupsi yang nyata. Manusia yang tidak adaptif dengan perubahan zaman, khususnya perkembangan ilmu pengetahuan dan teknologi, tentu akan memiliki masalah besar dalam kehidupannya. Dengan ilmu pengetahuan dan teknologi, aktivitas yang sebelumnya banyak dikerjakan secara langsung oleh manusia mulai tergantikan oleh beberapa produk ilmu pengetahuan dan teknologi, baik secara revolusioner maupun evolusioner. Efisiensi menjadi kata dan sekaligus jargon utama yang acap kali digaungkan agar manusia mudah di dalam kehidupannya. Namun pada sisi lain, perkembangan ilmu pengetahuan dan teknologi dengan efisiensi sebagai jargon utamanya justru tidak jarang bersifat kontraproduktif dan bahkan juga cenderung destruktif bagi kehidupan dalam arti yang luas. Efisiensi melalui kemajuan ilmu pengetahuan dan teknologi seringkali juga melahirkan suatu fenomena dehumanisasi. Dengan kemajuan ilmu pengetahuan dan teknologi, manusia terkadang hanyut dalam keyakinan bahwa ilmu pengetahuan dan teknologi bersifat omnipotens, sehingga manusia meyakini bahwa ilmu pengetahuan dan teknologi dapat menggantikan seluruh potensi yang sejatinya dan sejak awal hanya Tuhan yang menganugerahkan itu secara spesifik kepada manusia. Dengan ilmu pengetahuan dan teknologi, sertakan dengan dalih efisiensi, peran kalbu manusia sering menjadi semakin marginal dalam suatu pembentukan hukum. Penggunaan rasio secara berlebihan oleh manusia sejatinya beberapa kali Allah ingatkan dalam kitab suci Al-Quran. Saya pun meyakini bahwa peringatan Tuhan bagi manusia untuk senantiasa menyeimbangkan peran kalbu dan rasio dalam kehidupan juga termuat dalam berbagai kitab suci agama lain, meskipun mungkin dalam narasi yang sedikit berbeda. Nah, fenomena inilah yang nampaknya disadari oleh para penyusun 4 kali perubahan Undang-Undang Dasar tahun 1945 yang dilakukan dalam kurun waktu 1999 sampai 2002. Mulai perubahan pertama, perubahan kedua, perubahan ketiga, dan perubahan keempat. Yang hingga kemudian mereka mencantumkan suatu kata yang penuh makna, yakni efisiensi berkeadilan. Dalam pasal 33 ayat 4 Undang-Undang Dasar Negara Republik Indonesia tahun 1945 sebagai salah satu hasil nyata dari perubahan yang keempat Undang-Undang Dasar yang selengkapnya berbunyi, perekonomian nasional diselenggarakan berdasar atas demokrasi ekonomi dengan prinsip kebersamaan, efisiensi. Nah, ini disebutkan efisiensi berkeadilan, berkelanjutan, berwawasan lingkungan, kemandirian, serta dengan menjaga keseimbangan, kemajuan, dan kesatuan ekonomi nasional. Pencantuman teks atau nas pasal 33 ayat 4 Undang-Undang Dasar Negara Republik Indonesia tahun 1945 ini menjadi momentum baru bagi segenap bangsa Indonesia dalam kegiatan perekonomiannya. Teks atau nas pasal tersebut menjadi suatu koridor baru bagi filosofi, esensi, dan nilai-nilai yang harus senantiasa menjadi suatu yang mutlak, kondisio sine qua non, sekaligus menjadi landasan penting bagi setiap aktivitas ekonomi yang melibatkan kepentingan segenap bangsa Indonesia. Kata efisiensi berkeadilan dalam pasal 33 ayat 4 Undang-Undang Dasar Negara Republik Indonesia tahun 1945 tersebut memang pada awalnya lahir sebagai suatu produk politik yang kompromistik guna menjadi pilihan yang paling moderat, wasatiyah atau wastiyah, dari berbagai pemikiran dan ideologi ekonomi yang mempengaruhi momentum serta konteks 4 kali perubahan Undang-Undang Dasar Negara Republik Indonesia tahun 1945 yang berlangsung dalam kurun waktu 1999 sampai 2002. Namun dalam perkembangannya, kata efisiensi berkeadilan dalam pasal 33 ayat 4 Undang-Undang Dasar Negara Republik Indonesia tahun 1945 tersebut menjadi salah satu bukti nyata bahwa Undang-Undang Dasar Negara Republik Indonesia tahun 1945 sejatinya merupakan konstitusi tertulis yang adaptif bagi perubahan zaman sebagai suatu keniscayaan. Berdasarkan pasal 33 ayat 3 Undang-Undang Dasar Negara Republik Indonesia tahun 1945 tersebut, aktivitas ekonomi yang melibatkan kepentingan segenap bangsa Indonesia, baik negara, setiap warga negara, maupun setiap badan hukum Indonesia, tidak boleh terbatas hanya untuk mengandalkan tercapainya suatu efisiensi semata, melainkan sekali lagi efisiensi berkeadilan. Oleh karena itu, setiap produk hukum, ya antara lain peraturan perundang-undangan, perjanjian internasional, peraturan kebijakan ini yang lebih rendah atau disebut dengan peraturan kebijaksanaan dan sebagainya, khususnya di bidang perekonomian. Sekali lagi saya ingin tegaskan, khususnya di bidang perekonomian, wajib senantiasa tunduk pada konsep efisiensi berkeadilan sebagai satu prinsip konstitusi yang terkandung dalam konstitusi kita. Para hadirin yang berbahagia, pedoman konstitusional bagi setiap aktivitas perekonomian yang melibatkan kepentingan segenap bangsa Indonesia, baik negara, setiap warga negara, maupun setiap badan hukum Indonesia, secara lebih mendasar juga tercantum dalam alinea keempat pembukaan Undang-Undang Dasar Negara Republik Indonesia tahun 1945, yakni melindungi segenap bangsa Indonesia dan seluruh tumpah darah Indonesia, dan untuk memajukan kesejahteraan umum, mencerdaskan kehidupan bangsa, dan ikut melaksanakan ketertiban dunia yang berdasarkan kemerdekaan, perdamaian abadi, dan keadilan sosial. Hal ini secara historik dan visioner merupakan tujuan yang paling mendasar bagi dibentuknya suatu pemerintah negara Indonesia. Terwujudnya keadilan sosial bagi seluruh rakyat Indonesia sebagai salah satu tujuan dibentuknya suatu pemerintahan negara Indonesia menurut alinea keempat pembukaan Undang-Undang Dasar Negara Republik Indonesia tahun 1945 ini juga tercantum dalam sila kelima Pancasila sebagai sumber dari segala sumber hukum negara. Selain merupakan suatu konstitusi tertulis yang adaptif bagi perubahan zaman, Undang-Undang Dasar tahun 1945 juga dapat dipahami sebagai konstitusi yang berketuhanan, godly constitution. Jika dikaitkan dengan relevansi dan arti penting syariah sebagai salah satu hukum yang bersumber dari firman Tuhan dalam dunia digital dan smart society 5.0, maka Undang-Undang Dasar Negara Republik Indonesia tahun 1945 dapat dijadikan sebagai salah satu contoh terbaik, best practice, sebagai salah satu kondisi dari konstitusi di dunia yang memberikan pedoman bagi urgensi keseimbangan antara peran Tuhan dan peran manusia dalam dinamika perubahan zaman. Hal ini nampak sejalan dengan salah satu kutipan firman Allah dalam surat Ar-Ra'd ayat 11. Innallaha la yughayyiru ma biqaumin hatta yughayyiru ma bi anfusihim. Sesungguhnya Allah tidak akan mengubah keadaan suatu kaum sebelum mereka mengubah keadaan diri mereka sendiri. Oleh karena itu, manusia harus senantiasa mengoptimalkan dan melakukan terlebih dahulu setiap potensi dan upaya terbaik yang dapat mereka lakukan bagi peningkatan kesejahteraan suatu kaum atau umat manusia, sekaligus juga menyadari sepenuhnya segala keterbatasan yang ada pada dirinya agar terhindar dari keyakinan bahwa dengan ilmu pengetahuan dan teknologi seolah manusia dapat merasakan omnipotens terhadap segala hal. Ya, keterbatasannya. Kita lanjutkan. Dengan demikian, jelaslah bahwa Undang-Undang Dasar Negara Republik Indonesia tahun 45 merupakan salah satu contoh terbaik best practice apabila kita berupaya mencari contoh-contoh konstitusi negara di dunia yang dapat diklasifikasikan sebagai konstitusi yang berketuhanan, godly constitution. Mengingat begitu banyaknya kata Tuhan yang tercantum di dalam Undang-Undang Dasar tahun 1945 itu. Dalam praktek pembentukan hukum di Indonesia, baik pembentukan peraturan perundang-undangan maupun putusan pengadilan, terdapat pengakuan, recognize terhadap peran Tuhan agar setiap upaya penegakannya senantiasa mendapat keberkahan dan pertolongan dari Tuhan. Dalam setiap peraturan perundang-undangan di Indonesia terdapat frase dengan rahmat Tuhan yang Maha Esa pada bagian awalnya. Begitu juga dalam setiap putusan pengadilan yang juga diawali dengan irah-irah demi keadilan berdasarkan ketuhanan yang Maha Esa. Khusus untuk di lingkungan peradilan agama itu putusan itu selain demi keadilan berdasarkan Tuhan sama juga ada Bismillahirrahmanirrahim. Hal ini tidak-tidaknya menunjukkan dua hal penting. Pertama, bahwa Indonesia meskipun bukan merupakan negara yang berdasarkan atas agama tertentu, merupakan negara yang berdasar atas ketuhanan yang Maha Esa. Dan dua, setiap produk hukum yang melanggar ajaran-ajaran Tuhan harus dianggap bertentangan dengan Undang-Undang Dasar Negara Republik Indonesia tahun 1945, termasuk dan khususnya berbagai produk hukum di bidang perekonomian dan atau yang berkait dengan perkembangan ilmu pengetahuan dan teknologi. Pada awalnya, saat ditetapkan menjadi konstitusi di Republik Indonesia, tanggal 18 Agustus tahun 1945, Undang-Undang Dasar tahun 1945 memang belum memuat konsep dan istilah ilmu pengetahuan dan teknologi. Terlebih lagi transformasi digital. Namun dalam perkembangannya, para penyusun 4 kali perubahan Undang-Undang Dasar tahun 1945 secara tegas dan visioner mencantumkan dalam norma konstitusi dalam pasal 31 ayat 5 bahwa, ini saya kutip, pemerintah memajukan ilmu pengetahuan dan teknologi dengan menjunjung tinggi nilai-nilai agama dan persatuan bangsa untuk kemajuan peradaban serta kesejahteraan umat manusia. Sebagai salah satu hasil nyata dari perubahan keempat Undang-Undang Dasar Negara Republik Indonesia tahun 1945. Selain itu, dalam perubahan kedua Undang-Undang Dasar tahun 1945, pemanfaatan serta pengembangan ilmu pengetahuan dan teknologi juga telah diatur sebagai jaminan hak asasi manusia dalam pasal 28C dan pasal 28F Undang-Undang Dasar Negara Republik Indonesia tahun 1945. Dengan demikian, jika dikaitkan dengan tema konferensi internasional ini, yakni tantangan syariah dalam dunia digital dan smart society 5.0, Indonesia sejatinya telah memiliki landasan konstitusional yang tegas dan visioner bahwa kemajuan dan pemajuan ilmu pengetahuan dan teknologi merupakan tugas pemerintah yang harus dilakukan dengan syarat utama menjunjung tinggi nilai-nilai agama. Setelah syarat ini terpenuhi, barulah dipenuhi pula syarat-syarat lain bahwa suatu pemajuan ilmu pengetahuan dan teknologi juga harus dilakukan demi persatuan bangsa dalam arti pengutamaan kepentingan nasional, tetapi sekaligus juga ditujukan untuk kemajuan peradaban serta kesejahteraan umat manusia, agar negara, setiap warga negara maupun setiap badan hukum Indonesia tidak terjebak pada sifat dan sikap chauvinistik. Adapun terkait konsep smart society, Islam sejatinya menawarkan konsep masyarakat madani sebagai suatu tantangan sosial dan tatanan kemasyarakatan yang diterapkan oleh Rasulullah SAW pasca disepakatinya Piagam Madinah atau Madinah Charter, yang tentunya saya juga asumsikan cukup familiar di kalangan para ahli perbandingan hukum, comparative legal scholars yang hadir dalam konferensi yang terhormat ini. Para hadirin yang berbahagia, pada akhirnya salah satu tantangan besar bagi kita sebagai umat manusia dan warga dunia dalam konteks transformasi digital untuk mewujudkan smart society di era 5.0 ini adalah memastikan terwujudnya kesejahteraan umum bagi warga dunia. Inilah sedikit sumbang pemikiran yang dapat saya sampaikan, kiranya dapat bermanfaat menjadi pemicu dan pemacu lahirnya berbagai pemikiran yang brilian dan visioner dalam konferensi ini untuk nantinya dapat dipikirkan, dikembangkan, atau bahkan dikritisi secara konkret dan konstruktif oleh para pembicara, para pembahas, para peserta dalam konferensi internasional ini. Semoga setiap tetes pemikiran yang lahir dari proses pertukaran pemikiran dan pengayaan multi perspektif dalam konferensi internasional ini mendapatkan keberkahan dan dapat dinilai sebagai amal ibadah kita oleh Allah Subhanahu wa taala dan bermanfaat bagi kehidupan dan kesejahteraan umum untuk seluruh warga dunia. Atas perhatiannya saya mengucapkan terima kasih. Semoga Allah Subhanahu wa taala senantiasa menuntun kita pada jalan yang lurus. Wallahul muwaffiq ila aqwamit thoriq. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much for the Honorable Chief Justice of the Constitutional Court, Bapak Dr. Wahiduddin Adam SH.MH. In his speech, he emphasized on the integration of science, knowledge, and technology and religion in the national building of Indonesia. And then now we come to the second keynote speech, Professor Dr. Mashpuri Abdullah. I would like to read his brief CV. He was born December 22nd, 1958. and then graduated from the Faculty of Sharia and Law, Win Syarif Hidayatullah, Jakarta. And then he also graduated from Doctor of Philosophy in Islamic Studies at the Department of Middle Eastern History and Culture, the University of Hamburg, and continue his postdoctoral program via Fulbright Visiting Scholar at Boston University, USA in 2020. Currently, he is the Professor of Islamic Law at the Faculty of Sharia and Law, Win Syarif Hidayatullah, Jakarta, and also Special Advisor of the Vice President of the Republic of Indonesia, and also the Vice Chairman of Advisory Board of Indonesian Council of Ulama. He has already prepared a very best paper on Islamic law and politics in the context of the globalization. And it's 16 pages. And I'm sorry, Prof, because of the limitation of the time, we allocate 30 minutes for this second keynote speech because we also already have also the foreign speaker at the scheduled time. So time is yours, Prof. Dr. Mashpuri Abdullah. No, this is the second keynote speaker. Yeah, I'm sorry because there is a little bit adjustment because of the time. Minutes. Yeah, ladies and gentlemen, please welcome Professor Dr. Mashpuri Abdullah.
Assalamualaikum warahmatullahi wabarakatuh. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. Honorable Dr. Wahiduddin Adam, Dr. Professor Dr. Talabi, as Dean of the Faculty of Sharia and Law and Vice Rector of State Islamic University of Mataram, Dr. Hashim Muhaishim, speakers of the conference and the participant of the conference. I thought that I'm not one of the speaker, the keynote speaker, but normal speaker. So I prepare paper and also PPT. I wrote my paper about 20 pages, and I would like to read some of the points Yeah, the first. The title of the paper is actually Islamic Law and Politics in the context of globalization. I will begin that this is, for me, it is important. I choose this title because there are some aspect of Islamic law and Islamic politics we must make re-istihad or new istihad. I would like to begin with the introduction that Islamic doctrines mostly had been practiced in personal, social, and political life since the Prophet period until the coming of Western colonialism. This is clear. Islamic law once became a Islamic law once became a positive law in Islamic Caliphate, Sultanate, and kingdoms. And the second, I think, the second point, Islamic law even had an influence on the European law as a result of interaction and exchange among them over the centuries around the Mediterranean. This is very important because you know that we talk about globalization, and the globalization began for a long time, especially before, it's even before pre-modern. So we call pre-modern globalization. At that time, Islam, for example, come to Indonesia. Islam came to Indonesia, to Malaysia, and to other countries outside the peninsula. Mean that there was globalization in the world, but at that time, the globalization occurs in the period of we call maybe society 2.1, 2.0, because the time we call agricultural society. So there was globalization, but the globalization went not long as right now. So Islamic law is not spread not only in the Muslim country or Muslim society, but also in Europe, especially Mediterranean area. It also brought about reducing the coming Western colonialists to the Muslim countries, side power in property in Muslim sultanate and kingdom. This is the problem because at the time the colonialists come to Muslim country, not only Indonesia, but also the majority of Muslim people in the world. It also brought about reducing the existence of Sharia or Islamic law among its adherents by introducing their legal system instead of Islamic legal system. Yeah, but we actually Muslim countries, this was very strong. Why, if the Western people came to territory, come to country at the time, but area, for example, and they were not Muslim, but maybe Buddhist or Hindu, and there's penetration of Western religion to the country. But Islam, most Muslim people can defend that Islam is their religion, except maybe Philippines. The majority of Philippine people at that time, before coming of Western colonies, were Muslim. But after the coming of Western people, Western colonialists, the majority of Filipinos became Catholic. The adoption of Western civilization continued as the impact of modernization and globalization, even after the end of colonial rule in the Muslim countries. This is the definition of globalization. I think it is, we know all about the definition of globalization, but I would say that that globalization began since a long time, even before the coming of modernity or modern time. It is today becoming an unavoidable process that occurs in all countries in the world, which means global independence and exchange among them. This bring about new set of ethic and norm of human relations that in certain aspect lead to the change of the world view as well as social, economic, and political system in the world. Next. Since not 1970, I would like, since 1980 maybe more proper, because then the process of globalization is running rapidly in all countries in the world, which is mainly supported by the existence of internet and other information technology, as well as modern transportation. So this era is referred to as the era of digital society, society 4.0. This condition then produce what so-called homogenization. This is very important, which means increasing similarity between and among different societies of the world, and hegemonization, which means the paradoxical concentration of power in a particular country or in particular civilization. This is introduced by Ali Mashpuri. So because of globalization, there is similarity. We have dress, for example. Dress, there is no difference between Indonesian dress and American dress, for example. Or okay, there's many certain society or social community that still have own dress, for example, Saudi Arabia. But but many people of Saudi Arabia, outside Arabia, for example, if they go to Europe or to America or to even to Indonesia, they wear not the traditional dress, but Western dress. There are several examples of the influence, especially democracy and human rights. As regard to the human right protection, for example, the West has encouraged the world to recognize and to protect practices of lesbian, gay, bisexual, and transgender, LGBT. This is actually the culture, the Western culture. Even though this had actually violated the social values that exist in certain countries, especially Muslim countries, but they encourage or they disseminate this idea if that everybody or every country, every society that cannot respect the existence of LGBT, this means that they do not recognize or do not respect human rights. This is maybe the crucial point of the socialization of globalization. Those who reject globalization because of its there are some opinion about globalization, including among Muslim society, and there are three opinions among Muslim scholar or Muslim intellectual about globalization. The first is those who reject globalization, and the second is those who fully support globalization. The first is supported by Islamists or fundamentalists, but the second is supported by secular Muslim. The second is those who accept globalization in accordance with national interest and Islamic teaching and identity. This is moderate. If I think we most of Indonesian of Muslim ulama or Muslim intellectual in ulama support this third opinion. So I mean moderate. We accept globalization as far as not contrary to Islamic law, to Islamic Sharia. Yeah. Next. The process of globalization, this is impact of Islamic politics. The process of globalization that went hand in hand with colonialization and modernization changed political system in the most Muslim countries. Since the end of the World War II, there have been political reform in the Muslim countries, which can be classified into three forms, namely monarchy, constitutional monarchy, and republic. Muslim countries have adopted Western political system, especially nation state, this two, constitutionalism, democracy, and protecting human rights. This is, I think almost all Muslim countries and almost all Muslim society, almost all Muslim intellectual accept and support this system, nation state, constitutionalism, democracy, and protecting human rights. Some of them even introduce secular political system, which mean separation of state and religion, such as Turkey, Azerbaijan, and Tajikistan. This is the impact of modernization on globalization. We know that some countries, even many countries in the world, many Muslim countries introduce their political system as secularism, such as even Turkey. You know that secularism in Turkey is stipulated in its constitution. So everything cannot change except maybe by referendum. This is the problem in Turkey. Even right now, because Erdogan is the leader of Muslim Brotherhood, but we cannot change Turkey as the Muslim Islamic state because many observers said that Erdogan would like to develop modern Turkey into Ottoman Empire or Turkey like Ottoman Empire. And then the major theme of political theorists in classical and medieval period was the concept of caliphate. Although some ulama, such as Ibn Jama'ah and Ibn Taymiyyah, did not support this institution because the caliphate system is not based on qat'iyud dalalah, definite and clear argument or dalil, but it is the result of ijtihad of the ulama based on maslahah. As-siyasah ma kana fi'lan yakunu ma'un nas aqrab ila as-salah wa ab'adan al-fasad. In accordance with the globalization, all Muslim countries apply the concept of nation state. So I think no one of the Muslim Islamic countries right now or Muslim countries right now that support Caliphate system, even in Saudi Arabia. But right now, if a Muslim scholar or ulama, for example, said that I would like to support Caliphate system, and then the ulama will be jailed by the government. This is in Turkey, but in Indonesia, until now, there is a sermon of religious sermon that support Caliphate state. Today, the majority of ulama accept the concept of nation state. This concept exactly does not conflict with Islamic teaching because Al-Quran, Surat Al-Hujurat 13, say, وَجَعَلْنَاكُمْ شُعُوبًا وَقَبَائِلَ, and made you into nation and tribe so that you may know one another. This means that it is possible for Muslim rights, to develop their system, their state system or political system, not based on caliphate, but nation state, because it is also introduced in the Quran. And next, although Islam legitimized it is in the second, constitutionalism. Although Islam legitimized the need for a constitution as a basic rule of state, practiced by the Prophet Muhammad in the form of Constitution of the Medina. In fact, almost all Muslim countries enacted their constitution just after they achieved independence at the end of the World War II. Saudi Arabia, for example, had no constitution until the early 1990s. In 1992, this country enacted the basic regulation, the called An-Nizam al-Asasi al-Hukm. The Saudi people or the Saudi government did not support the term constitution because they said that our constitution is Al-Quran as-Sunnah. Dusturna wal Quran was Sunnah. So instead of constitution, Saudi people or Saudi government use the term An-Nizam al-Asasi lil-Hukm. The formation of the Constitutive Assembly and the regional administration system, Nizam al-Muqata'at al-Idariyah. Yeah, there is. So what is the position of Islam in the Constitution? There are 6 groups. The first is those that stipulate that Islam is the state religion. The head of state should be Muslim, and the Sharia is national law, such as Saudi Arabia, Iran, Pakistan, South Sudan, and Libya. There's clearly in the constitution that this country are based on Islamic law. So we call Islamic state. Those that stipulate that Islam is the state religion, the head of state should be Muslim, and the Sharia is the major source of legislation, such as Syria, Egypt also. Egypt included in the third group. Those that stipulate that Islam is the state religion and the Sharia is the major source of legislation, such as Egypt, Kuwait, Qatar, and the United Arab Emirates. That's only the first group that introduced Islamic law or Sharia to be national law. Those that stipulate that Islam is the state religion and the head of state should be Muslim, such as Tunisia, Algeria, and others. Those that stipulate that Islam is the state religion, such as Jordan, Malaysia, and others. This is the sixth, this is our country. Those that do not mention Islam in their constitution, as in the case of Turkey and Indonesia, but there are differences. In Indonesia, although there is no term, no word Islam, but there is God, as Dr. Wahiduddin Adam said. There is Pancasila, and there is also Article 29. There is clearly stated that there is the state is based on the belief on God. But Turkey, there is clearly exactly that Turkey is based on secularism in their constitution. Yeah, almost this is democracy. Almost all government in the Muslim countries characterize their political system as democratic or are moving toward democratization, although many of them do not implement democracy or practice democracy substantively. Next. Yeah, there are various opinions of the ulama. I think next, because this is we know, but in fact, so there are in the first there is a first opinion about democracy according to the ulama and Muslim intellectual, but there is the fact in Muslim countries about who government the government that support democracy, and there is four group. First, countries that practice democracy substantively, namely Indonesia, Tunisia, Turkey, Malaysia, and Nigeria. Also, might be there are also up and down. For example, Turkey. Maybe 2 decades ago, Turkey was considered in the most democratic country in the world, but not today, because the level of democracy in Turkey today is very low. Many people said that Turkey do not support democracy anymore. For example, this is under the leadership of Erdogan. You know, Erdogan is the leader of Ikhwanul Muslimun, and every organization that opposed him is considered as the enemy. Like Gulen. Yeah. Gulen, for example, the people who participant of the Gulen Institute, for example, the Gulen organization, for example, are considered as opposition, and they should be brought to jail. Countries that are making effort to democratization, such as Pakistan, Lebanon, Jordan, Bangladesh, and Morocco, and the third, countries that support democracy but not yet substantively enough. Egypt, for example, the government of Egypt government said that our system is democracy, but in fact there is not substantively. Maybe only formal democracy, like in Indonesia during the New Order period. Egypt, Syria, Algeria, Iran, and Sudan. Even in Iran, for example, if we go to Iran, and maybe we can discuss with Iran intellectual, intellectual or Iran ulama, they said that our system is democracy, but in fact that is only formally. Countries that do not promote democracy, but simply promote justice as the basic principle in the state policy, such as Saudi Arabia and other Gulf countries, they do not support democracy. But they said that we cannot support democracy because democracy is not in line with our culture. But in fact, that's more political. If they change their political system to democracy, this means that their system can be changed from monarchy to be a republic, or maybe to monarchy, or maybe constitutional monarchy. And this will be reduced their power. The adoption of Western law continued, this is application in Sharia, as the impact of modernization and globalization, even after the end of the colonial rules in the Muslim countries. This has changed the position of Islamic law in many Muslim countries. And on the other hand, this has impacted the necessity of reinterpretation of Islamic law as response to social change as well as the development of social science and technology. About the position of Islamic law, part of it, I have said in the previous explanation. Next, this is only in the first group. Most Muslim countries enacted Islamic family law, and many of them enacted other private law such as Islamic business law and so on. In many countries there are efforts to Islamization of national law. This is actually not only Indonesia. There are in the world, there are process of secularization, and there are also process of desecularization. I have a book written by Peter Berger, for example, in 1990s. He wrote his book on the title of Desecularization of the World. At the time, I also met him in Boston University because he is a professor at Boston University, about the background of his writing on this book. And actually, not only in Muslim countries, but also in Western countries, there are action, there are movement against secularization. So there are Islamization, there are effort of Islamization of national law in two ways. The first way, adoption and application of Islamic law to be national law through legal and constitutional ways. And the second, total application of Islamic law through social movement or even revolution. Yeah, this is like the second is like in Iran, for example, there is a change of Islamic of national law to be more Islamic, to be Islamic law. And next, the globalization also impact of necessity of reinterpretation of no ijtihad towards certain provision of Islamic law that are not compatible with modern perspective and challenge, especially those are based on relative meaning text, Nasrani and Nasrani. There are four factors. I think there's clear where that we should make no ijtihad to change the provision of certain Islamic law. Next. Yeah, this is especially the provision of certain Islamic law that are not compatible with the existing condition, especially related to Society 4.0 will be discussed. The goal of Society 4.0 is create a human-centric society in which both economic development and the resolution of societal challenges are achieved, and people can enjoy high quality of life that is fully active and comfortable. This is important because we can also, or we should also make reinterpretation of Islamic law, especially the position of non-Muslim and the concept of jihad. Next, this is about jihad. According to many classical ulama, Islam invite non-Muslim to convert to Islam, but if they refuse it, they must be fought. So that there is an offensive jihad, hujumiyah, al-jihad lil-hujum, Today, only ulama and radical fundamentalists support the offensive jihad, especially the founder of Salafi, Muhammad bin Abdul Wahab, and the leader of Ikhwan, especially Said Qutb. This opinion based, among other things, by the several verses which are understood literally without regard to the context of revelation of the verses of Sababun Nuzul. So there are some verses that introduce jihad as offensive action. But if we understand the verses by paying attention to the Asbabun Nuzul, all of the verses introduce that the verses that is jihad not defensive. The war is not defensive but offensive. Yeah, this is, for example, this Islam does not prohibit Muslim from having good relationship with non-Muslim. Allah does not forbid you. La yanhakumullahu 'anil ladina lam yuqatilukum. The verses of war stipulated Quran Taubah, for example, literally indicate the meaning of offensive war. But when viewed from the context of revelation as Asbabun Nuzul, those verses show that all wars ordered by Allah are defensive. I think it's okay, or only yeah.
Waalaikumsalam warahmatullahi wabarakatuh. Jazakallah khairan katsiran wa khairan jazaa wa ahsanal jazaa to Professor Dr. Mashpuri Abdullah. Very tight keynote speech on the responses of Muslim country toward democracy and also the ramification of the Islamization of law in those Islamic countries and then in the Islamic countries, and also how this could also support the digital transformation toward the society 5.0. Okay, thank you very much, Prof. Mushkori Abdullah. Yeah, because of the limited time we have, so we do not have a question and answer, but if you have any question and answer for Professor Mashpuri Abdullah, you can also send the question to the email or to the WhatsApp. Okay, ladies and gentlemen, this is the end of the keynote speech 1 and keynote speech 2. Thank you very much for both keynote speaker, Chief Justice Bapak Dr. Wahiduddin Adams SH.MH and Professor Dr. Mashpuri Abdullah. On behalf of the committee, we would like to thank you very much for all your attention and sorry for any inconveniences. Billahi taufiq walhidayah, wallahul muwafiq ila aqwamit thoriq. Wassalamualaikum warahmatullahi wabarakatuh. We come to the second session, will be chaired by Ibu Windy Triana, PhD.
Teman, selamat pagi Bapak Ibu. Assalamualaikum warahmatullahi wabarakatuh. We have already Professor Tim Lindsey here. Selamat pagi Pak Tim.
Selamat pagi, Dr. Windy.
Okay, ladies and gentlemen, we'll continue to our next session. Here we have Professor Tim Lindsey from the University of Melbourne Law School. Professor Tim Lindsey is one of Australia's leading experts in Indonesian law, and he is the advisor of Indonesian government, business, international organization, court, and legal practitioner in Indonesia and Australia. And he is a Malcolm Smith Professor of Asian Law, Redmond Barry Distinguished Professor and Director of Center of Indonesian Law, Islam and Society in Melbourne Law School. And Professor Lindsey has won National and University Teaching Award and was an ARC Federation Fellow from 2006 to 2011. And amazingly, Professor Lindsey has 100 publications, including those about Indonesia, like Indonesian Law and Society, The Strangers Next Door, Indonesia and Australia in the Asian Century, and the founder and an executive director of the Australian Journal of Asian Law. Pak Tim, we have here our rector, Professor Amani Lubis, and we have Dr. Wahiduddin Adam, Chief Justice of Constitutional Court, and we have Prof. Mashpuri Abdullah. And now the time is yours. Silakan Pak Tim.
Thank you very much, Wendy, for that kind introduction, and thank you to all of you. It's a pleasure to be here. I'm very happy to be invited to see my friends from UIN Jakarta, Sharif Hidayatullah. So hello to everybody, and thank you. I wish I was in Lombok, but I'm not. I'm stuck in Australia where it's still very cold. So I hope to see you all in Jakarta down at Depok sometime soon. Today I'm going to speak to you about criminal justice in Indonesia, and in particular about the death penalty. I'm going to share my screen, so I'll do that now. The screen sharing has been disabled by the host. Okay, I'll try again. Thank you. That's great. Thank you. Okay. Thank you for that. So I'm going to talk to you today about the Sustainable Development Goal 16, which is peace, justice, and strong institutions. Promote the rule of law at national and international levels and ensure equal access to justice for all. Develop effective, accountable, transparent institutions at all levels. These are not easy objectives to achieve, and in truth, very few countries have been able to fully realize them. But today I want to examine Indonesia's progress towards achieving Goal 16 by looking at a criminal justice case study involving a case I worked on with LBH Masyarakat, particularly with Ricky Gunawan, Aisha Humaida, and also with my daughter Samira. So the facts of this case, which is a death penalty case, are as follows. On 17 May 1995, the Tembilahan District Court in Riau sentenced an uneducated, poor and illiterate farmer from a remote village called Sakak bin Jumat to death for the murder of another villager and his wife and child. In September 1995, Sakak was moved to the Cipinang prison, where he was placed on death row, awaiting execution. He filed 2 clemency applications that were both rejected, and he remained on death row for the next quarter of a century, waiting for an execution that never happened. Like many other prisoners left in limbo on death row for many years, Sakak's mental and physical health deteriorated very badly over time. 2 decades after he was convicted, LBH Masyarakat began to represent Sakak. But in July 2020, they were told by Cipinang prison that he had died in prison in August that year due to malnutrition and limited access to medical services as a result of the pandemic. As his family could not afford to bury him, Sakak's body was disposed of by prison authorities. Now, there must be serious doubts about whether Sakak was guilty, or at least about the level of his involvement in the murders. And as I will show you, these doubts were not properly addressed during the criminal process to which he was subjected largely due to repeated failures to respect his rights in Indonesian law. These failures included a lack of proper legal representation and what seems to have been a very unfair trial, procedurally and substantively. But even if Sakak did commit the crimes, his punishment, being left in limbo on death row for a quarter of a century, exceeded what was appropriate. In all, his case raises important questions about the fairness and integrity of the criminal justice system, and especially capital punishment regime. And of course, the Millennium Development Goals criteria 16 of rule of law, right to equal access to justice, and whether criminal justice institutions are effective, accountable, and transparent. The best way to demonstrate this to you is to explain to you, satu demi satu, the rights Sakak had in Indonesian law that were ignored or marginalized from the day of his arrest until his death 25 years later. The first one is a right to documentation. A full understanding of what happened to Sakak is made very difficult by the fact that almost no proper records recording the process he went through with the police or regarding his trial exist. This is despite Pasal 72 of KUHAP, which says that at the request of the suspect or legal advisor, the official concerned shall provide a copy of a report of examination for the purposes of defense. Now, this right should exist for the benefit of accused persons, but it usually doesn't for two reasons. First, the police report is only to be provided in response to a formal request, and that request is often ignored. And second, even if the report is provided, it may not contain a true and complete record of the questioning. Pasal 143 of KUHAP adds that copies of the letter submitting the case together with the letter of indictment shall be provided to the suspect or holder of his power of attorney or his legal advisor and investigator. At the same time, the case submission letter is given to the district court. Now, this letter of submission includes the indictment and the case file, and its submission to court leads to the case being set down for trial. This provision of KUHAP, this pasal, is meant to ensure that all the material relevant to the case against the accused is given to the accused or to his or her lawyers, so a proper defense can be prepared. Now, in this case, Sakak and his original lawyer were never given copies of the police investigation report, which at trial was said to contain his confession, and nor was the prosecution's submission letter provided to Sakak and his lawyers. In fact, copies of the police investigation report and the submission letter and the material given to the court have never been located. They may have been lost or they may not have existed. Sakak was also never given a copy of the decision of the Pengadilan Negeri in his case by which he was sentenced to death. And this is contrary to Pasal 226 of KUHAP, which says that a copy of a court's verdict or decision shall be given to the jaksa and the police, while to a defendant and his or her legal advisor, it shall be given only upon request. This is perhaps at odds with Pasal 52A of Law 2 of 1986 on the General Courts, which states, quote, the court must convey a copy of the court decision to parties within 14 working days of when the decision is pronounced. However, regardless of these two provisions, Sakak was never given a copy of the decision of the district court by which he received the death sentence. After a long search, LBHM was able to find a barely readable copy of the court's judgment from an employee of the court who had long since left employment and happened to have it in his personal records. And this became the only documentation of Sakak's arrest, questioning, and trial. But of course, like many court decisions, it is of limited value for understanding what actually happened in court. Because although Pasal 197 of KUHAP lists the material that must be included in a court decision in a criminal case, it does not require the court to record the arguments put by the defense. The judgment in Sakak, or the putusan in Sakak's case, therefore, just gives only a few short sentences to the defense case. That means it's very hard to know what actually happened in this case. The missing records of Sakak's questioning by the police and the prosecution case submitted to the court make it very difficult for LBHM to decide whether his rights as an accused person were respected, although it is very unlikely that they were. The next right I want to consider is the right to legal advice. Sakak said that he was not legally represented during police questioning, and there is no evidence that he had a lawyer at that point. This is a clear breach of Pasal 54 and 56 of KUHAP. The right to legal advice is established by Pasal 54 of KUHAP, which says that for the purposes of his or her defense, a suspect or defendant has the right to obtain legal assistance from one or more legal advisors during the period and at every level of examination according to the procedure determined by this law. And Article 55 adds that a suspect or defendant has the right to choose his own legal advisor. Now, of course, for a poor illiterate farmer like Sakak, he was not capable of choosing his own legal advisor. However, Pasal 114 provides that in the event a person is suspected of committing a criminal act before the commencement of examination by the investigator is obliged to inform him of his right to obtain legal assistance, or that he must be accompanied by a legal advisor, as stated in Pasal 56. Now, in reality, these rights are very weak, and many people detained by the police in Indonesia have no lawyer present during questioning, so it's not unusual. This is because the police often do not tell them about this right, so they don't know about it. And of course, it's well documented that many people held by the police report that they are threatened with violence or tougher penalties if they get a lawyer. This has been commented on by many scholars and lawyers. Many suspects therefore decline legal advice even if it is offered. However, in some cases, including death penalty cases, the presence of lawyers is mandatory. It must happen. Pasal 56 says that where a suspect is suspected of or charged with having committed a criminal act which attracts the death sentence or a prison term of 15 years or more, they must have their own legal advisor, and the official concerned at all levels of examination must appoint a legal advisor for them. Pasal 56 adds that legal advisors will be provided free of charge. However, KUHAP does not deal with how the appointed lawyer will be paid for their legal services. This is obviously a clear disincentive for lawyers that the court may appoint for poor defendants. There's no arrangement made in law for how they will be paid, and it means that the quality of representation provided by lawyers in these cases is unfortunately very low, as Harahap has commented. Even when an experienced legal advisor is available, the lawyer's ability to assist the accused person is limited by Pasal 115 of KUHAP. This states that when an investigator is examining a suspect, the legal advisor can follow the course of the examination by watching and listening to the examination. Now, this is a strange provision because it makes the role of the lawyer a passive one. It doesn't give them a right to intervene. Indeed, it is common for lawyers to be restricted to merely being present, and some even refuse the opportunity to advise their client if it is offered. And this is true even in death penalty cases, where the quality of defense provided by free and often unpaid legal counsel is, as Harahap says, disappointing. He said they, quote, seem to lack motivation, unquote. At the end of questioning, the accused person is usually asked to sign legal assistance minutes. This is a record to be provided to the judge at trial to show that a lawyer attended the accused's questioning by investigators. But the accused signature on this record does not necessarily mean he or she actually received any legal assistance. It just means that the lawyer was there. The lawyer might not even have spoken, as is often the case. In Sakak's case, an Indonesian language statement was signed by him with a fingerprint was presented to court as evidence that he had confessed to the crime. I'll just repeat that. An Indonesian language document signed by Sakak with a fingerprint was said to be evidence that he confessed to the crime. This document was crucial to the prosecution case, and the court relied on the confession. There must be great doubt as to the validity of this key document for two reasons. First, Sakak was not legally represented when he put his fingerprint on that document. Secondly, he could not possibly have understood that document because he could not read and he could not speak Indonesian. And he was not provided with an interpreter to translate that into a language he understood. He signed with his fingerprint because he can't read or write, and he could not speak the language the document was written in. How could he know what he was signing? The use of the purported confession is also concerning because Kakak said it was obtained as a result of violence. He said he was beaten until he agreed to put his fingerprint on the document, not knowing what was in it. And this, of course, is in breach of Pasal 52 of KUHP, which says that the suspect or defendant has the right to give information freely, that is, without duress, to the police or judge. In other words, a right to be free from that sort of pressure. I want to look at this right to an interpreter. Article 51 of KUHP says that to prepare the defense, a suspect has a right to be clearly informed in a language he or she understands about what is claimed against him at the start of the examination, and has a right to be informed in the language he understands about the charge brought against him. Article 177 adds that if the defendant doesn't understand the Indonesian language, then the judge chairing the session must appoint an interpreter to interpret in a language he understands. Now, although it is up to the judge chairing the hearing to appoint an interpreter, judges often don't do so unless they are asked by either the prosecution or defense lawyer. This is because, again, there is no law that clearly states who is responsible for paying the interpreter. There's also no clear test which can be applied to determine whether the accused needs that assistance or not. As I said, Sakak could only speak a few words of Bahasa Indonesia at the time of his arrest. But the police investigations and the court proceedings were all conducted in Indonesian, and Sakak was never given an interpreter or translator. Even if the police had used a language he understood, Sakak was illiterate and he could not have understood the documents he was required to read or sign, such as the confession. In short, Sakak's right to be clearly informed in a language he understood of the allegations against him was completely ignored throughout the long legal process that led him to be sitting in death row waiting for execution. Right to a fair trial. Indonesian laws do not, in fact, clearly establish a right to a fair trial. However, it is possible to infer similar rights from Chapter 10A of the Indonesian Constitution. For example, Pasal 28(1) of the Constitution recognizes a right to legal recognition, guarantees protection and certainty, and to equal treatment before the law. Pasal 27(1) reiterates the right to equal treatment before the law. The Constitutional Court has also said that reference in the Constitution to Indonesia as a negara hukum means due process is imperative. However, these are important protections. These protections are essential in Pasal 28D and 27. but they are not the same as a clear guarantee of a fair trial. Moreover, as we all know, there is no judicial remedy for failure to respect a constitutional right in Indonesia. There is a right to ask the Constitutional Court to review a statute and maybe strike it out if it is contrary to the Constitution, but there is no clear judicial remedy for failure to respect a constitutional right, for the breach of a constitutional right, as there is in the constitutional courts of some countries. In some Indonesian undang-undang do contain some procedural safeguards intended to protect the rights of suspects and defendants at trial, although there is no clear statement of a right to silence. As well as a right to lawyers, other rights and suspects and defendants include the presumption of innocence, which is Pasal 8 Ayat 1 of Law 48 of 2009 on judicial powers, and also in the Law on Human Rights, and the right to be free of the burden of proof, in other words, to be presumed innocent until proven guilty in Pasal 66 of KUHP. But all of these, while important rights, fall short of a right to a fair trial. But even if there was a basic right to a fair trial, there are at least two reasons to doubt that this right was respected in Sakak's case. First, as mentioned, he was not provided with an interpreter at trial. He was also not provided with documents he was entitled to see. Second, he seems to have received ineffective legal representation. It does appear he was represented at trial, although not before, by an apparently unpaid lawyer appointed by the court. But no effort seems to have been made by that lawyer to get him an interpreter or oppose the prosecution's reliance on the purported confession. The failure to raise these issues at trial made it almost impossible for Sakak to avoid conviction. Now, of course, he could have appealed his conviction to the Pengadilan Tinggi in Riau. He has a right to do that under Pasal 233 Ayat 2 of KUHP within 7 days. But no appeal was lodged on behalf of Sakak. There was no appeal lodged. Of course, he could also apply for reconsideration for peninjauan kembali under Pasal 263 of KUHP, but he never made an application for peninjauan kembali because he didn't know that he could. The only other remedy left to Sakak is clemency. An unknown person, probably his trial lawyer, filed a clemency application on Sakak's behalf just 9 days after the putusan in the Tembilihan Pengadilan Negeri. And he filed that clemency application without Sakak's knowledge. In other words, the time for appeal to the Pengadilan Tinggi finished. 2 days later, the clemency application was lodged. And that meant that from that time on, his trial lawyer had no further responsibility. This suggests that the trial lawyer may have made a decision just to abandon Sakak's right to appeal or to seek reconsideration and lodge clemency. Why he did that is not clear, but he certainly was freed from responsibility for Sakak from then on. That may have been a motivating factor for a lawyer who's probably not paid for his services. This may be supported by the fact that the clemency application was extremely basic and brief, just 1 page with only 4 lines of argument. In any case, the clemency application was not dealt with for about 5 years when it was rejected by President Gus Dur. But a copy of his decision was never given to Sakak, and a copy of Gus Dur's decision has never been provided by the government, despite requests from LBHM. In fact, it looks as though the decision by President Abdurrahman Wahid was lost. 2 years after his first clemency application was rejected, a second one was filed on Sakak's behalf, again by an unknown person. This document was as short as the first one, and it was filed in May 2000. This time, 2002. This time, however, the application was accompanied by a letter from Dr. Albert Hasibuan of Komnas HAM. He had conducted an investigation into Sakak's case, and he concluded that Sakak said he was innocent but had been poorly represented by a lawyer provided by the state at his trial and had not been given a copy of the judgment in his case and had not been able to appeal. And he asked that the second clemency application be considered carefully. However, El-Bahar was told by government officials that the second clemency application was rejected by President Megawati. But again, a copy of the relevant presidential decision was never given to Sakak, even though Pasal 12 of the Clemency Law says this must be done within 14 days. Again, no copy of this decision has ever been found in government records. It doesn't seem to exist, despite Freedom of Information requests. Now, this is important. Obviously, it's important because if a clemency has been refused, the document needs to be presented to the person so they know they are facing death. But it's also important because Pasal 13 of the Clemency Law says that a prisoner who has received the death penalty and has applied for clemency cannot be executed until he or she receives the presidential decision rejecting the application. Sakak never received it, and that means he had no choice but to simply wait on death row. He couldn't be executed because he never received the clemency decision by President Megawati. So he was stuck there on death row indefinitely, getting physically and mentally sicker and sicker until eventually he just died. So, where does this leave us? Again, I don't know whether Sakak committed the crimes that he was accused of. But even if he did, being abandoned to wait for execution that could happen any day, in his mind, for a quarter of a century was an extreme punishment. If he hadn't committed the crimes, then he was effectively being tortured. And he became ill with what is known in scholarly literature as death row syndrome, physical and mental illness brought on by being left on death row indefinitely without knowing your fate. The flawed legal process that led to Sakak being convicted, sentenced to death, and then left to die on death row is a reminder of the problems of criminal justice in Indonesia. Regardless of guilt or innocence, individuals like Sakak have very limited capacity because of their poverty and their illiteracy and their poor education. They have very limited capacity to exercise their rights and obtain procedurally and substantively fair treatment by law enforcers. And so they are vulnerable to abuse and neglect of their rights. And that's what happened in this case. And he's not the only prisoner who was left on death row for a quarter of a century. There's at least one other, maybe two others. For Indonesia to move closer to achieving Sustainable Development Goal 16 by fulfilling the rule of law and a right to equal justice for all, and ensuring its criminal justice institutions are effective, accountable, and transparent, that's the wording of Goal 16, it is clear from Sakak's case that basic criminal law reforms are needed, including the following. First of all, there need to be clearer and more effective remedies for breaches of the procedural rules in KUHP, including penalties for those who breach them. In other words, the procedural rules need to be given force. There need to be penalties for people who ignore the rights that suspects have. There need to be stronger and clearer rights to legal representation and provision of legal documents and interpreters. Provision of legal documents should be mandatory. So should the provision of interpreters. And Sakak is not the only case where people have received the death penalty without being able to understand the court proceedings in which they're involved. More often this happens to foreigners, but it's happened to at least one other accused person from Riau as well. And there need to be consequences for breaches of the rights to legal representation, legal documents, and interpreters. To achieve these things, though, there need to be clear rules about public funding for lawyers and interpreters who are provided by the courts. There needs to be proper monies provided to fund that, and there needs to be proper rules and accountability so that those who are given these tasks are properly paid to improve the quality of the work they do. New rules of evidence are needed to prevent courts from using evidence obtained from investigations where procedural rules have been broken. For example, by failure to provide documentation. There needs to be reform of the Clemency Law, which lacks proper procedural guidance. It is procedurally quite empty. Reform of that to make it more effective is also important. But perhaps one of the most important guarantees that is needed is a constitutional guarantee that is absolutely clear of a procedurally and substantively fair trial, with a clear right to judicial relief if that right is violated. And that right and relief should also be confirmed in an undang-undang, so that it is a right that can be enforced in courts. I understand that this would require an amendment to the Constitution, and I understand that is difficult, but at the very least that right could be placed in an undang-undang. Finally, in my view, prisoners who've been left on death row for more than 10 years should probably have their sentences commuted to becoming a life sentence or 20 years, rather than leaving them to wait for an execution that could happen every day and never does. Some of these reforms that I've mentioned are in the draft bill, the Rancangan Undang-Undang, to reform KUHP and the KUHP, but not all of them, and maybe not in the same detail I'm calling for. But these reforms are all urgently needed and they must be enforced. Sakak is just one case that I've explained to you in some detail to show you how failure of rights becomes systemic in an individual case. But I think we all know that these sorts of abuses are common with poor and powerless defendants. These reforms are needed and must be enforced if Indonesia is to fulfill Sustainable Development Goal 16. Thank you very much.
Many thanks, Pak Tim. Now I would like to invite from the participants to ask questions. We have 5 more minutes for question and answer. Ladies and gentlemen, online and offline participants, please. Okay, Pak Tim, we have question here from Ibu Fitria.
Good morning, Pak Tim. Thank you very much. I read your book on Indonesian law. It's give lots to my dissertation actually, and I thank you very much about that. And then I just want to give 2 short questions. First is about, do you think the question of the death penalty in Indonesia is rather more law or politics or law? Because as we know that the president is granted the right to give the clemency. So. And also if we relate it to the Australian 39 case, I know that it's, the discourses is not that is so hot there in Australia, because as I read that it's, maybe Australian people see it, it's more politics than law. So
sorry, could you just, sorry, that second question, I didn't quite hear it.
So it's about it's not about the case that you talk about, but it's about the death sentence in general. Do you think that the question of the death penalty in Indonesia is rather more politics or law? And secondly, I just want you to give us some opinion about, the discourse of death penalty in Indonesia, and how will the discourse of the abolition of the death penalty in the international sphere influence the revision of the KUHP in Indonesia? As I know that the death penalty is no longer as the main sentence and it's become the relative, the alternative sentence as far as I read in the newspaper, because I'm not really, in my domain, but I want you to have a highlight on how the international, law or influence the discourse of the death penalty in Indonesia.
Thank you.
Tim, we have one more question. Is that okay? Or
Yeah, please.
Bapak Ibu silahkan dengan bahasa Indonesia. Pak Tim bahasa Indonesianya sangat baik sekali.
Sangat tidak.
We have Pak Mujarid.
Okay, thank you very much, Pak Lindsey. We feel proud to can meet you here in the meeting. You just explained about Piagam Jakarta. We in Indonesia will know about your opinion, how your opinion about the Piagam Jakarta or Jakarta Charter in Indonesia. Especially many of Indonesian people, mereka itu masih menganggap that the Jakarta Charter is still alive in Indonesia. Thank you very much.
Pak Tim, you may answer the questions.
Thank you very much. Thank you, Ibu Fitria, Pak Mujahir, and Ibu Windy. The reform of the death penalty in Indonesia, I think, is probably a low priority for most people. And however, that's not true globally. The European Union abolition of the death penalty has triggered a trend around the world towards abolitionism. Now, that is not a consistent trend, but in many countries, the European Union lead has led to either abolition of the death penalty or a moratorium on the death penalty so that it is not practiced. Indonesia had previously been on a path towards abolition when the death penalty was being less commonly used, but that has changed in the last decade, which has reversed the trajectory. So Indonesia has used the death penalty principally in relation to narcotics, drugs offences and terrorism offences. Indonesia doesn't tend to use the death penalty so often for other serious crimes. It's mainly used for drugs offences and for terrorism offences. The Rancangan Undang-Undang KUHP dan Criminal Code and Criminal Procedure Code do have a provision in that would, first of all, mean that the death penalty will be less commonly used, and also that after a person has been on death row waiting for a certain period of time, 10 years, then if they have been of good behaviour, there is a procedure by which the death penalty can be commuted to become life imprisonment or maybe a lesser sentence of up to 20 years. That creates a new process by which a person who is not executed for 10 years can actually have their sentence remitted. And that reflects the international view that people should not be left for long periods on death row awaiting execution, because it's a double punishment. They've received the death penalty punishment, but they're also receiving a long term of imprisonment. And it's well established that that combination creates severe mental and physical illness in people. So this initiative in the draft bills is a good one, because it would satisfy political demands for the death penalty. Despite the international climate shifting, Indonesia still wishes to retain the death penalty. It would allow that to happen, but would create a process by which all persons who are convicted, if they are of good behaviour, have a opportunity to have their sentence then reduced. And that would prevent what has happened in this particular case. I think there's a lot of problems with the draft bills on the Criminal Code and the Criminal Procedure Code. There's a lot in them that is not good, but I think that particular reform, both to reduce it as to make it less likely that judges will award it in the first place, and secondly, to give an opportunity for the accused person to have their death sentence commuted to life or a term of imprisonment, are major important reforms, which I hope come through as quickly as possible to prevent this sort of event happening. I do think it is a pity that the death penalty is often a matter of politics. President Jokowi, during his election campaigns, said that he would not grant mercy to drugs offenders, and his anti-drugs campaign relied heavily on the death penalty, and that led to the large number of executions in his first term. In other words, there was a political motivation for the renewal of executions in Indonesia, but that's not unusual. One of the arguments against the death penalty all around the world is that it is always political, because the people who make the final decision are the heads of government. In every system, it's the president or the prime minister or the governor, whoever it might be, who makes that last decision, and that makes it a political decision. The advantage of the reform that's being put into the draft bills is that it would stop it being a political decision. It would be a matter of the prisoner's good behaviour rather than a political decision for the head of state. Likewise, clemency should be taken out of the political sphere and should be turned into a process which is clearly set out in legislation to remove the political content from it. My preference would be to abolish the death penalty completely for two reasons, because the research data shows clearly that around about a third of all people executed are usually innocent, and that's been proven through DNA research back into earlier crimes where people have been executed. And secondly, because the actual decision of whether someone dies or not is usually a political decision, and I think that's, as a lawyer, wrong. These matters should be legal decisions, not political decisions. And if they are going to be political, then we should stop imposing this form of punishment. Having said that, these reforms that I proposed are very tough ones, difficult ones, and whilst dealing with execution itself is important, it's also important to get the basic rights of suspects and defendants clarified and enforced. Even if they're not going to receive the death penalty, they should have their rights to legal representation, to having documents, to having interpreters, to having a fair trial respected. And they're reforms that should be made a priority in the course of reforming KUHP and KUHP. I don't think they have, however, which concerns me. As to the Piagam Jakarta, I understand the argument, Pak Mujahir, that there are people in Indonesia who think it's still part of the constitution. And I know that was an argument that was run in the 1950s, and attempts to reintroduce the Piagam Jakarta led to the deadlock in the Constituante in the 1950s. But that argument really died during the process of constitutional amendment in the era Pasca Suharto, because that proposal to reintroduce the Piagam Jakarta was defeated in the debates in the MPR by a vote. So whether or not it was part of the original constitution, and it probably wasn't, it was probably removed, it was voted against in the Pasca Suharto amendment process, and that excludes it from the constitution from that time onwards at least. So thank you.
Thank you very much, Pak Tim. That's the end of our session. And thank you so much for the rich insight on the issue of death penalty in Indonesia. We wish to see you again, maybe in the next Iclj. Thank you very much. Sampai jumpa, Pak Tim.
Thank you. It's an honor to be invited and a real pleasure to see my friends again. Thank you very much. Terima kasih.
Terima kasih Pak Tim.
Terima kasih kami ucapkan atas kehadiran dari Hakim Konstitusi Republik Indonesia, Bapak Dr. Widen Adams. Terima kasih. Dan juga Profesor Mashpuri Abdullah yang telah menghadiri acara Iclj ke-6 di Lombok. Ladies and gentlemen, we will come to the next invited speaker. Will be delivered by Professor Dr. Ladies and gentlemen, for the next agenda for today will be parallel session, and the group also has already divided in the group.
Oke, bahasa Indonesia aja ya Bapak Ibu sekalian. Sudah dibagi grup panel jam 11, sebenarnya jam 11, jadi mundur ya jam 11.30 sampai 12.30. Ada sedikit perubahan di sini untuk panel Bu Nur. Saya pikir masing-masing sudah punya ininya ya grup panelnya. Untuk yang Bu Nur itu dipecah karena Bu Nur berhalangan jadi moderator. Untuk Bu Nur 3 orang yaitu Pak Nahrawi dan Pak Muhammad Sadi bisa dipindah ke grupnya Pak Indra dan Pak Abdullah ke grupnya saya sebagai moderator. Untuk yang tidak masuk dalam panel pagi ini bisa untuk mengikuti atau terlibat dalam diskusi ya, mendengar dan memberikan pertanyaan. Itu yang lebih kami harapkan dibandingkan mungkin break keluar gitu ya. Jadi karena paralel sampai besok, jadi pasti tidak setiap pasti ada peserta itu ada saatnya harus tidak presentasi. Nah disitulah tetap untuk menyimak, yaitu bergabung dengan panel-panel yang lain sehingga kemudian diskusi bisa hidup ya, masing-masing peserta bisa menyampaikan pertanyaan dan tanggapannya terhadap jalannya panel diskusi di masing-masing sesi. Tempatnya tetap di sini, Ibu Bapak sekalian. Peserta kami panitia akan membagikan meja-mejanya. Silakan barangkali teman-teman. Yang pertama di panel saya bacakan aja ya, jadi siap. Yang akan segera berdiskusi yaitu pertama di parallel session 1. This is the online session actually will be moderated by Ibu Windy, Pak Muhammad Zakiri, Muhammad Taufik, Pak Yayan Sofyan, and Nadia Khalimah will be online. And the second online session will be moderated by Ibu Umi Kulsum, which is attended by Saifuddin Herlambang, Bapak Hasan Ali, Pak Jamaliyah Halidroh, dan Bapak Tri Hidayati. So every of the members can, like join the discussion, and the offline parallel session first will be with me, Bu Ova dan Mr. Samiullah Adel, ya, and also Pak Abdullah, as I said before. So the fourth will be moderated by Pak Indra Rahmatullah, Pak Sofa dan Mas Kufa, Pak Sofa dan Ibu Mas Kufa, Pak Nur Hanifah, Pak Samsu Fajrin. Okay, so there will be like 4 sessions, 2 offline and 2 online. So for the rest, please keep here, don't go outside, just be part of the session. Ya, teman-teman tolong bagiin dong itu yang ada 1A, 1 di meja-meja di sini, jadi masing-masing tahu tempatnya, mohon. So the online session will, please Bu Windy dan Bu Umi, please share the online session. Yeah. The breakout, please first, the breakout first and the second breakout. And the last, the other 2 panel C with me here, yang dengan saya di sini, 1C, Mashrofa dan Mr. Samiullah Adel, and also like Pak Abdullah here with me, and then the last one will be moderated Pak Indra. And Pak Indra will chair the discussion there, okay? Online linknya. So Pak Indra there. And the rest, please just be part of the. If you want to, kita di sini aja. And for the other, you can like join either online or offline. So the online link will be, the online link Zoom will be shared soon. So the participant who will not participate this session, you can like choose either here or online. Okay. And the rest, please, you can join either here or there or the online session. Okay, thank you. Please join. The participants can join. You are very welcome to join here or there. Or the participant, please join. Yeah, you can hear. Yeah, you can hear. Yeah. With us. Please join the. Tolong teman-teman bisa bantu pindahkan kursi untuk bisa mereka bergabung di join. Bisa boleh yang online bisa join yang online atau yang offline ya Ibu Bapak sekalian. Yang online akan di-share di grup general participant.
Bu, maaf saya belum ada umumnya ya, berarti langsung ya Bu.
Mohon yang lainnya bisa bergabung either online or offline. So kita semua jadi produktif ya untuk mengikuti acara ini semuanya secara baik.
Bapak Ibu yang masih di Zoom silakan untuk masuk ke breakout.
kan. Nah, sini meja sebaris ini kan undangan ini. Sebaris B. Sebaris B yang meja ke sebaris pakai kursi jok. Ya, kursi. Nah,
Info tambahan, kita akan masuk lagu nanti jam siang jam 14.00. Jadi istirahatnya cukup di sini saja. Nanti ya istirahat di sholat, kemudian
Aku coba dulu ya, Le. Kamu cuy. Audionya. Coba keluar.
Assalamualaikum. I'm just testing to see if everything is in order. If you can hear me. Can you hear me?
Cek satu. Cek, cek. Cek satu, cek, cek. Cek, cek. Cek satu, cek. Cek satu. Cek. Cek.
Professor Musa, are you there?
Bapak sekalian, mohon memasuki ruang acara. Kita akan segera mulai sesi berikutnya.
Shall I start now? Can you hear me?
Sorry, Prof, we still have some trouble on the technical thing, so it might take some few minutes then. Thank you.
Can I share my own screen or will you be sharing the screen?
If you think that you can share, we will off
Yes,
our
I
sharing
can
then.
share.
Sure,
I can
sure.
share. Yeah.
Sure, thank you.
Okay, thank you. You can just let me know when to start, eh?
Okay.
Okay.
Start, just a second, Prof.
Yes. I can hear you. Can you hear me?
Yes, we do.
Okay, so I will share my own screen, okay?
All right.
You can just let me know when to start, then I will start, inshallah.
Okay, shall we start now? Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirrahmanirrahim. We are very fortunate here because we have Professor Najma Musa, which is coming from the Faculty of Law, University of the Western Cape, South Africa. And I would like first thank the audience for continuing the session. I think I will start first by reading Professor Najma Musa's background. So, as I said before, he is from the Faculty of Law University of the Western Cape, South Africa. He has published many chapters, publications, articles, etc. And one of the upcoming chapter will be about the constitutional implications of homosexual sexual orientation, homosexuality, same-sex civil marriage, and nikah for succession, inheritance right, and testamentary freedom of homosexuality in Muslim in South Africa. The International Survey of Family Law, and it will be published in September 2020. We know that South Africa is very diverse country in terms of religion, ethnicity, and the diversity also is reflected in its legal system. So as far as I know, maybe Professor Najma will correct me if I'm mistaken. So there's a mixed and hybrid common law system because the South African legal system draws from various other legal systems, including among others Roman law, Roman Dutch law, English common law, German. And we all know that Indonesian can also learn from the South Africa, as Indonesia is also diverse, and its legal system is influenced by civil law system, Islamic, and as well as other. Professor Najma will be speaking about women's legal center trust versus President of the Republic of South Africa and others. It's for 2020, very recent issues, and will be listening to her presentation. And without further ado, I think I will give the floor to Professor, you can start.
Can you see me? Can you see me as well? Let me unshare. Okay. Can you see me? Assalamu alaikum and it's good morning in South Africa, and I think it's good afternoon in Indonesia. And thank you very much for that introduction. And yes, South Africa has a very important link, the South African Muslims with the Indonesian Muslims, because Islam came to South Africa from Indonesia and India. So we have a 350-year history of Islam in South Africa, thanks to Dutch and English colonialism, and inadvertently Islam was brought to South Africa via the Indonesian exiles during that period. So that is when we start with Islam in South Africa. So my presentation today is a case note exactly on which deals with Muslim marriages in South Africa. So if I can, as the case was introduced, we have a Muslim marriages case recently in our highest court in South Africa, and that was the Women's Legal Center Trust case versus the President of South Africa and others. So the Women's Legal Center Trust is an NGO that has taken on women's cases, Muslim women's cases, especially for the last couple of years, and have been trying, Muslim women have been going to the Women's Legal Center for support and for the recognition of their marriages, which up until today, 350 years later, is still not recognized. So today I'm going to be talking about this case. And if you remember at the last year's conference, I also did a presentation about the framework plan for legal recognition and regulation of Muslim marriages in South Africa. And there in that paper, can you hear me? Can you hear me now?
Can't hear you. Okay, could you try again?
Can you hear me now? Can you hear me now? My volume is at its highest. Can you hear me? Can you hear me now?
Very clear. Thank you.
Okay, thank you. So my presentation today will be about this case where the Women's Legal Center has, can you see my screen? Can you see the whole screen? Okay, so what has happened is I'm going to be discussing this case because this is the first time that a Muslim marriages case has come before the Constitutional Court, and the Constitutional Court, which is the highest court in South Africa, has actually ruled on Muslim marriages. And as I've indicated in this slide here that I've spoken about, I've published a paper in the Ahkam Journal, which where you can find this information. So I'm going to continue from last year's presentation. So basically, I don't know why my screen is not sharing correctly. Okay. So basically what has happened is that on the 28th of June of this year, the Constitutional Court handed down a much awaited judgment on the recognition of Muslim marriages. So does this judgment mean that Muslim marriages or marriages that were concluded purely in terms of Islamic law or the Sharia, does it mean that such marriages are recognized in South Africa? The simple answer is no. And I will give you the rationale for this conclusion, and is to be found in the two-pronged judgment. The judgment can be divided into two parts. The first part of the judgment is wholly suspended and will only and automatically come into effect if remedial legislation is not enacted within 24 months. In other words, the court has given the state 2 years within which to introduce legislation to recognize Muslim marriages, failing which then the first part of the judgment will come into effect. So let me continue. So the second part of the judgment pertains to interim relief, which applies immediately. In other words, it applies retrospectively to all nikahs that exist as at the time when the case was first introduced in the Western Cape High Court, and that is the 15th December 2014. So we had the case in the Western Cape High Court, and from there it moved to the Supreme Court of Appeal. So the judgment is backdated to 15 December 2014. So, and it also applies to nikahs, which although they were terminated by talaq before that date, if there were still proceedings, legal proceedings ongoing from that date, it will apply to such nikahs as well. So, okay, so now I'm going. So I briefly referred to the first part of the judgment. What does it mean? And my main focus will then be on the second part of the judgment pertaining to interim relief, to highlight for you, and I'm just going to summarize it as I go on, to highlight to you that there are some practical problems that will be faced and encountered by couples when effect is given to orders pertaining to such interim relief. And I will look at the judgment by showing you 3 fictitious examples. And so this judgment is very confusing, and lawyers who will be dealing with this will find that if we look at these scenarios, they will encounter many practical problems. And then in conclusion, I provide a few critical comments of the judgment and tell you why I think there is a lot of problems with this judgment. So in our past experience, we have seen that the government only springs into action when it's election time. So our next presidential election coincidentally also coincides with 2024, by which time the state is supposed to introduce legislation to recognize Muslim marriages. So normally many promises are made before election time to get the vote of Muslims, but then after that, very little happens. So until then, the non-recognition of Muslim marriages will continue to be proved burdensome to Muslim women and children. Muslim men are mostly happy with the status quo because as long as Muslim marriages are unrecognized, then they are no longer, then they can get off lightly. So our courts have slowly but surely been introducing secular relief to Muslim women and children, but that is not the ideal situation and the ideal scenario because Muslim marriages are still recognized in South Africa, the nikah marriages. So the first part of the judgment, we see that in the first part of the judgment, the court declared that Secular Marriage Act and the Secular Divorce Act are unconstitutional because they fail to recognize Muslim marriages as valid marriages for all purposes, and they fail to recognize, most importantly, the consequences flowing from such recognition. So let me just move my sound. Okay, and the consequences. So not only are Muslim marriages not recognized, but all the consequences flowing from recognition pertaining to maintenance, custody, inheritance, etc., none of that is recognized as well. So the Divorce Act, it was said, fails to safeguard the welfare of children born from Muslim marriages in a similar way that all other children in other marriages are safeguarded in South Africa. And it also fails to provide for the redistribution and forfeiture of assets of Muslim marriages that would be just for Muslim women. So that was the first part of the judgment, and the court declared that the common law definition of a marriage is inconsistent with the definition of a marriage in South Africa because it excludes Muslim marriages. So in South Africa at the moment, we have 3 marriages that are formally recognized in South Africa, and that is African customary marriages, which is based on custom. And then we also have gay marriages recognized. So same-sex marriages are recognized in South Africa. but none of the religious marriages are recognized in South Africa. So a Hindu marriage is not recognized, as a Jewish marriage is not recognized, and Muslim marriage is not recognized. The default marriage act that we have in South Africa, which the court now says is unconstitutional, actually is based on Christian values and norms, and therefore when a Christian person gets married, in terms of that act, his marriage is automatically recognized, and it also has Christian leanings in the act itself, which is now also going to be amended to be more inclusive to everybody. So the Constitutional Court suspended its declaration of invalidity, as I said, for 24 months in order to give the government an opportunity to enact new legislation to recognize marriages or to amend existing legislation that would recognize Muslim marriages as valid and would also regulate the consequences. And in my previous article, the article that was just published by Ahkam in this year, I tell you what the options are currently that South Africa is considering in this regard, both the government in the form of the Department of Home Affairs and in the Ministry of Justice. So in the second part of the judgment, which is what I want to focus on to highlight some problem areas, is that we look at the interim measures which will prescribe how a Muslim marriage should be concluded with regard to consent and age requirements. Now we see that as far as consent and age requirements are concerned, there is a lot of problems here. And I also look at the dissolution of a marriage in terms of the rules applicable to a Muslim monogamous marriage, where a man has one wife, or the rule applicable to where he has more than one wife in a polygynous marriage. So why is this interim relief important? The interim relief is important because of the current status of non-recognition of Muslim marriages. Formally, Muslim marriages are non-recognized in South Africa. And as I've indicated, there have been a number of attempts to enact legislation to govern Muslim marriages. And we have a 2010 Muslim Marriages Bill, which if it has been published, but it has not been enacted by government. Should it be enacted, it would recognize Muslim marriages plus its consequences. And it would also provide for all the practical scenarios of that marriage. So that is why we need recognition of the Muslim marriages. So we look at the three scenarios. The first scenario we look at is a case where we take the person Ahmad, he's 18 years old and he wants to marry Layla, who is 17 years old. In terms of Islamic law and subject to the interim relief granted in terms of age and consent requirements. Then we look at the second scenario where Adam is married to Amina in terms of Islamic law only. The marriage was concluded before the judgment, and one of the parties want to dissolve the marriage in terms of the interim relief granted. So we see that then we look at the third scenario is where a couple, Musa and Bilqis, were married in terms of Islamic law only prior to the judgment and now want to dissolve their marriage. So if we look at the first requirement, and I'm not going to go into too much detail, but I will just explain it to you in a nutshell so that I can answer some questions. So in the first part, in the first case, we see that there is a problem because if a child is below the age of 18, which is the age of marriage in terms of the Children's Act in South Africa, then you cannot get married, without consent of parents, without consent of the minister. So the court has also said that in a case of a Muslim marriage, the African Marriages Act must apply to a Muslim marriage in the interim. And this is problematic because African customary marriages are based on custom and not religion. And in terms of this act, both parties must be 18 years of age. And this will be a problem because in terms of Islamic law, we have makes provision for the marriages of minors to get married below the age of 18. So a girl below the age of 18 can get married below the age of from the age of 12 onwards, for example. So this is a problem. So I'm not going to go into all that details. I will tell you what is the solution is current solution is that many imams are registered as Muslim civil marriage officers. So if you get married in terms of the Marriage Act, then the Marriage Act provides a loophole because it says that it doesn't require a person to be 18 years of age. So in other words, if Layla wants to get married and she's below the age of 18, she can get married in terms of the Marriage Act, and then a marriage can be registered as a marriage in terms of South African law. However, as it stands now, the case does not mean that Muslim children below the age of 18 can get married and that marriage can be registered. So it will require a lot of consent requirements before that marriage can take place. The Muslim marriages bill that I was talking about also says that you must be 18 years of age, and some Muslim countries have also regulated marriages to be 18. So we recommend that you have to be age 18 too in order to get married. So that was the scenario 1. The scenario 2 is when you wanted to dissolve your marriage in terms of the interim relief required, then it would be dissolved in terms of the Divorce Act. Now that is also a problem. Does the court have jurisdiction to dissolve your marriage in terms of the Divorce Act? We are saying the judgment is not clear how it's going to apply, and it raises questions of religious entanglement. Is the court now going to dissolve the marriage? And if so, does it mean that the Muslim marriage is also dissolved? Is a nikah also dissolved? So normally when a nikah, a Muslim man then normally has the right to issue the talaq, and not the woman unless she has a fasakh, ask for a fasakh and that. So there's a lot of issues here. We have a section in our Divorce Act. The Divorce Act has been amended, which says that that we have a section in the Divorce Act which says that courts can refuse to offer you a civil divorce if your religious divorce has not taken place yet, because otherwise you would have a hanging marriage. You would be divorced in terms of the civil law, but not divorced in terms of the religious law. So that is another problem we perceive to be with that scenario in terms of the interim leave. We can say, yes, the marriage has been broken down irretrievably, and therefore it's like a ground of shikak, which is also found under the fasakh form of divorce in the Muslim Marriages Bill. But of course, the husband can oppose the divorce application made by the wife and argue that she would not be free to remarry unless he first grants her the talaq. So there is a confusion in this regard, and lawyers would not know how to deal with this. And so that is the second issue. And so I've explained all of that. So we are saying that what you should do is to ask the court to become involved and to get the religious ulama bodies to become involved to introduce the to provide the facilitate the talaq. So the third issue deals with patrimonial consequences. We are saying a Muslim marriage, in terms of our understanding in Islamic law, is that the marriage is out of community of property without the cruel. In other words, what is yours and what is mine is mine. The courts are saying no. The Muslim woman, the marriage can be out of community of property unless the parties agreed to the contrary. But when there is a divorce like this, the courts will give the wife a fair share in the growth of that estate, so the accrual. So if they have, for example, the parties have accrued 1 million in the estate after getting married, then the wife is entitled to half of that. So that is now what the court is saying, and the Islamic scholars are saying, but this is not what the Islamic law provides. So the court is giving fairness to Muslim women. So what are some criticisms for this case? It's a good case in that it is now finally putting the government to task. They have to recognize Muslim marriages, but there is a problem with this case because it, although it struck down provisions in these acts, it did not say that the Muslim marriage is valid. The judgment did not say outright that it must be recognized. In other words, the courts are not forcing government's hand, and they did not even ask them to, they only asked them to amend legislation and not even to develop the law. So in total, our courts For 12 years now, this has been going on, from case to case, from High Court to Supreme Court of Appeal, and now finally the Constitutional Court. Parliament has had 12 years almost to enforce amendments to these acts and to recognize Muslim marriages. This has happened since democracy was achieved in South Africa in 1997. We had a case of Ryland versus Edros, also in the Constitutional Court. And now the courts are, it appears that they say, look, we don't want to get involved in religious matters, but that is a smokescreen for judicial activism, because they have really done very little. The case doesn't even recognize Muslim marriages. So other cases, for example, we say that there's no reference to international law in the case. The Indian Supreme Court did a much better job, which is also the highest court in India, in the Shah Banu case, where it held that the Muslim woman was entitled to maintenance, maintenance after her divorce. So that is some of the criticisms. And in conclusion, I can say that we again see that the government is going to wait until election times before they're going to do anything concrete. And that basically concludes my presentation. We don't have much hope, but now the courts are forced to do something, and we await to see what will happen in the future, inshallah. And that is my presentation in a nutshell. So I can take some questions if you would like, and thank you very much for listening.
Thank you very much, Professor Najma. Now we will move to the Q&A session. So I invite the audiences both in here and to platform to deliver the questions to Professor Najma. Please raise your hand, okay? Is there any
Will you tell me the questions?
Okay, thank you so much, Professor Najma Musa. My name is Masrofa. I'm the lecturer of Sharia Law Faculty UIN Jakarta. Actually, I have some question for you, Professor. The first one is, how is the protection of women's and children's right after the divorce in South Africa? I would like to know more about that. And the second one is, how is to distinguish, I mean, for the woman who wants to get married, for Muslim and non-Muslim. Maybe I will give you some example, like in Indonesia, if a Muslim woman, if you want to get married, they will go to the KUA, Kantor Urusan Agama, and for non-Muslim, they will go to the civil court, Pengadilan Negeri. And then, and the third one is, how is the regulation and procedure of polygamy for Muslim in South Africa? And the next one is, how is the regulation of interfaith marriage in South Africa? Thank you so much.
Okay, shukran so very much for that question. It's quite a few questions. So the question is, at the moment, because Muslim marriages are not recognized, there is no protection for Muslim women unless they go to court on a case-by-case basis, and that is very expensive because Muslim women cannot afford this. So ulama will say, once they issue a talaq, they don't really force you to the husband to provide maintenance, and normally the Islamic law maintenance is only for 3 months after the divorce, which is very little. But Muslim women can claim in terms of the Maintenance Act, in terms of South African law. They can, on the cases have been amended now, where women have challenged on a case-by-case basis. So our Divorce Act has been amended, our Maintenance Act has been amended, our Inheritance Act has been amended. So if a husband dies without a will in South Africa, when he dies without a will, we say he dies intestate, and then the South African law will apply to give Muslim women her rights, for example. So women and children are suffering because of non-recognition, and that is the case, and that is why it is so important for the state to recognize these marriages and to afford protection to women. So in the case of a Muslim marriage, we see that when we get married in South Africa, it is normally just a nikah. So you will have an imam conducting the ceremony, and then you will get a nikah certificate. But now over 300 imams are registered as civil marriage officers. So in other words, they can perform the nikah and they can perform the civil marriage at the same time, and then your marriage is legally recognized. But the imams are refusing to, if you want a civil marriage, they want to dictate the terms of the marriage to say it must be out of community of property without a accrue. In other words, Muslim women get nothing upon the divorce or the end of the marriage by death. There is no you have your separate estates, whereas the South African law of the Marriage Act is default in community of property. So if you want to, you can just get married in terms without the imam. You can go, you have your nikah registered with the imam, you can get married in a mosque, and everybody gets married in terms of Islamic law. But then they can have the option to register their civil marriage either by going to a government office or through the imam. But if you don't want the imam to dictate the terms of your thing, you just go and to a magistrate can conduct that, or any other civil servant can do the civil marriage for you. So if you're non-Muslim, most non-Muslims then will go for the civil route. And in South Africa, the majority of the population is Black African, and most of them conduct marriage in terms of customary law, which is recognized. So that brings me to your next question of how is polygyny regulated in South Africa. Black African marriages recognize polygyny, but is very highly regulated. So the same would have been the case with Muslim marriages. If it was going to be recognized in terms of the Muslim Marriages Bill, we say to the husband, yes, you may have more than one wife, but it gives the first wife, an option to divorce the husband and ask for the division of the estate. He has to inform the wife. He has to get, the wife must be aware of it, and she must be, at least there is informed, the wife will be informed, because in many cases the wife doesn't know that the triple talaq has been issued or that she's been divorced. So we have a regulation which is very important in terms of the proposed bill. What the government is currently considering is not regulation, it is just recognition in terms of the proposals that they have. And that is very bad for Muslim women still, because it means that we're going to go back to square one. So it's very important that it's not only recognition, but it's a regulation of the marriages in terms of the act. And what about interfaith marriages? In terms of the Muslim marriage officers that are recognized as civil marriage officers, they will not conduct a nikah marriage or a civil marriage unless both parties are Muslim. So what they will do is that you will have a conversion process where the one party must become Muslim. So in other words, they still follow the traditional Islamic law in that case, where in the case of a Muslim man, he can marry a Christian wife in terms of Islamic law, but our ulama will not accept that. They will conduct the marriage for a Muslim man with a Christian wife, yes, but in terms of the civil law, they will say that both spouses must be Muslim. They will never conduct a marriage for a Muslim woman and a non-Muslim person unless that person has first converted. Although Islamic law says that you don't have to be a Muslim wife to marry a Muslim man, they still require a conversion. So, but in many cases, parties don't have to convert, and the marriages, there will be other imams that will conduct that marriage. We even have imams that will conduct a gay Muslim marriage for parties, and even a gay interfaith Muslim marriage. So in terms of the constitution, because we have a constitution that protects the rights of various sexual orientations and faiths, and so that is something that can be contested in a court if an imam, for example, wants to refuse it. But so far we have not had any contestations in court. So I hope I've answered all your questions.
Okay, is there any question from a Zoom participant here? You can ask directly or through chat. Is there any more questions?
I hope I've explained the situation in South Africa accurately and coherently, because it's very difficult to summarize in a short space of time, because initially I was going to speak the whole time, but then I was asked to give 10 minutes to question time. So that is not a problem. But yes, Muslims in South Africa have been here for 350 years. You know, Sheikh Yusuf of Makassar, he was exiled to South Africa. He died in South Africa and was buried here until his remains was returned to Indonesia. So we have a long history with Tuan Guru before that, and slaves and political exiles of high rank that came to South Africa and kept the faith alive. But it is a travesty of justice that for 350 years, Muslim marriages have still not been formally recognized in South Africa. So Muslim women are not sitting down. They are now, the case has gone to the highest the court in South Africa, and it took the government has another 2 years in which to decide. The interim relief that has been given now, the case was handed down by an acting judge. We would have expected the more senior judge to have delivered the judgment, and very little thought was given to the practical consequences. And that is why we give that 3 examples, just to show the practical problems that people are faced. So even though the courts are saying you have interim relief, you can register your marriage, in terms of customary law is very different from South Africa, from Islamic law. The customary law requires a lobola, which is similar to a dowry, for example, but there are very many differences in customary law, whereas religious law of Islamic law is very different to the customary law. So people are very unhappy with that. So today, can you, in terms of this case, can you go register a purely nikah, a Muslim marriage like a nikah, and get a recognition? The answer is no. If you die today and you've been married to your husband for 30 years, or the husband has been married to you for 30 years, your death certificate will say not married. And that is very sad, that you are now, when you die, you're still not recognized even in your death and not even in your marriage. So that is the situation currently in South Africa.
Thank you very much, Professor Najma. I think we run out of time, so it's enough. So we had a very fruitful discussion. We thank you so much for your insightful discussion, and let's give applause to Professor Najma.
Shukran very much, terima kasih, and thank you for those insightful questions, and I hope I've answered them sufficiently. Assalamualaikum, and thank you very much.
Assalamualaikum warahmatullahi wabarakatuh. Let's move to the, we have a 5 minutes break to continue. Okay, so we will have like 5 minutes to continue to our next presentations. Again, thank you so much, Professor Najma. I just want to hand it over to Pak Dr. Jejen to lead the next discussion.
Now we have a break for 5 minutes, right, Ibu Fitria?
Yeah.
Okay.
The speaker is there. I think you just can continue. You just can go on because our speaker is there now. Already joined the.
I cannot hear you. Your voice. So we can continue. Or?
Good afternoon, Cezanne. Can you hear me?
Good afternoon, Professor Lange. See you again.
Hello. It's good to see you again.
Good to see you again.
I think the only thing I need to do is to share my screen.
I think,
and then I'm ready.
Yeah.
I'm ready to go.
So, organizer, can you put Professor Lange as a
Oh, actually,
co-host?
I can do it myself, I think.
Okay. Yes.
Yeah.
So, okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much for all participants, professors, dean of the and rectors of the Islamic State University, and the dean of the Faculty of Islamic Law, Sharia and Islamic Law at the State Islamic University, para guru besar, all professors and staff. Now we'll continue to our next speakers, which is Professor Christian Lange, who will be speaking with us on his very interesting project. I heard his presentation a couple months ago here in Indonesia when he visited Yogyakarta and also Depok for an event here. And his presentation is very interesting and excellent. It's very rich as well. So I guess he will share a relatively similar project, which is very important for us, in which he will share with us how to use a very rich digital, let's say, repository or digital archives into our research, especially on Islamic law. So before further ado, I would like to briefly introduce Professor Lange. I believe everyone has already know him, but as a matter of formality, I would like to reintroduce Professor Christian Lange to all participants in Lombok. So I'm not in Lombok, Professor Lange, I'm in Jakarta. Most of our participant is in Lombok, and you are in Utrecht, I believe, or in the Netherlands. So we are from 3 different locations. Professor Christian Lange is a professor at the Utrecht University at the Department of Philosophy and Religious Studies. He graduated from Harvard University in 2006 for his PhD. And currently he is the director also at the Netherlands Inter-University Schools of Islamic Studies. This is a forum for all, I think, schools or university in the Netherlands who has Islamic Studies program. So they have an organization for their coordinations. And he's also a member of the Netherlands Academy of Art and Science in the Netherlands. I would like to read also some of his publication. He is very prominent scholars. Among his publications is Justice, Punishments, and the Medieval Muslim Imagination, published by Cambridge in 2008. And this is what is interesting, as I said to you before, Professor Lange also is the one who is most expert among us on Surga and Neraka, or on paradise and hell. He wrote Paradise and Hell in Islamic Traditions, published by Cambridge in 2016. And he also actually published a novel, but he didn't put it in the list. So Professor Lange, without further ado, I would like to give you opportunity for 20 minutes for your presentations. And after that will be followed by like 10 minutes or so for question and answers. The time is yours, Professor Lange.
Okay, thank you, Zezen, for this very kind introduction. I hope you can all hear me and that everybody is back in the room. Greetings to Lombok from Utrecht. And of course, also to all those who are attending this event online, like myself. I also want to thank Professor Ahmad Tulabi for inviting me, and also Mrs. Wendy Triana for helping and enabling me to talk to you today. So I will talk to you about a research project that I ran here at the University of Utrecht in the last 2 to 3 years or so, on the study of Islamic law by digital means and computational methods. It was a very experimental project with mixed results, as you will see. But anyway, before I talk more about these results, I want to introduce you just briefly to the digital corpus, the collection of digital texts in Islamic law that is available, and also introduce you to some of the problems involved in using this digital corpus. So first of all, the idea of studying a digital corpus of Islamic law or any other corpus, the basic idea is to enlist the help of computers to run quantitative analysis of large amounts of text and data analyses that a single researcher or even a team of researchers could not do by themselves. So the first idea then is, if you want to do this, is to simply collect a very large digital corpus of texts of Islamic law. And you want this corpus to be not only big, but you also want to define the parameters of the corpus. It has to be well defined. So in our case, for example, we decided to only focus on comprehensive furu al-fiqh works, texts in the genre of furu al-fiqh. But we left out, for example, usul al-fiqh or other genres, fatawa literature, you name it. You also want to have a corpus that is spread evenly across regions and across the centuries. If you want to say something about Islamic law in general, then it has to be spread over the different geographical regions and across the centuries. Of course, you want, well, if your ambition is to talk about Islamic law as a singular concept, then you want to include several schools of law, not just one. And you want the works that you have in this corpus to be roughly comparable in terms of size and content. So, you know, when you want to work on furu al-fiqh, as we did, we paid attention to the fact that, you know, all the major areas of the law, ibadat, muamalat, and jinayat would be in these works. Now, to begin with the good news, perhaps the available corpus of Arabic digital text is quite big. So there is hope that such a collection of furu al-fiqh can be put together. Most of the available digitized texts come from online repositories that I'm sure many of you will know: Al-Maktaba Shamila, Al-Maktaba Shi'iyya, Al-Jami' Kabir, and so on. These are repositories that overlap also to a great extent, and they keep evolving. Texts are being added as we speak. There's a very useful research initiative run in the UK and the United States. It's called Open ITI, or Islamic Text Initiative, that collects all these digital texts and puts them in one single repository, which is available on GitHub platform. So follow the link, and if you're interested, and play around with it. Arabic has one of the largest machine-readable corpora of texts, second, if at all, only to Chinese. There are above roughly 8,000 unique titles in this Arabic corpus, 1.1 billion words, more or less. So it's quite big, and it's larger, roughly 10 times larger than the entire corpus of classical Latin and Greek, if you take it together. So we're talking about something, you know, this is a very rough calculation. If one book is 3 centimeters wide, and you put all these books that have been digitized next to each other, then you get something like 250 meters of books on the shelves. So it's definitely too big to know by yourself. You can't study it yourself. A team will not be able to study it by themselves. You need the computer to help you. Islamic law is, of course, only one area of this digital corpus, but still it's much too big to know. I'm showing you here a screenshot of my version of Al-Maktaba Shamila with only the Hanafi Furu al-Fiqh section. Now, when you first start to look at internet-based digital text repositories such as Al-Maktaba Shamila, you think, oh, this is quite impressive. But if you look a little more closely, you will see that the people who build and who continue to develop Al-Maktaba Shamila use rather unclear and unexplained criteria for selecting their texts. And in fact, perhaps they don't use any selection criteria at all. They seem to, sometimes it seems as if they simply collect everything that is out there and happens to be available, or they make it available a bit at random. So the result is a very eclectic and discontinuous corpus. There is a whole lot of certain authors such as Ibn Taymiyyah and Ibn Qayyim al-Jawziyah, and a whole lot of texts from the 12th to the 16th century of the Common Era, but there's much less from other authors and from other centuries. So the corpus that is available on Al-Maktaba Shamila, as useful as it may be, is not representative. So in Utrecht, one important thing that we wanted to do is to create our own corpus that would be more representative. We formulated our goals in in as modest as possible terms. So we wanted to include, as I said in the beginning, comprehensive works of Furu al-Fiqh. If possible, they should be well-known or influential within a madhab. We wanted one Furu al-Fiqh work per school for each century from the 9th century CE to the 19th century. So if you do the math, this gives you 55 works. And here you see an overview of the corpus that we built. The dots are single works of Furu al-Fiqh. The bigger the dot, the larger the work. And this is the spread that we managed. This is the corpus that we managed to put together. So we focused on the four most well-known Sunni madhahib, and also included the Jafari school. Most of these texts came from Al-Maktaba Al-Shamila and the large Shi'i digital collections, and we checked these holdings. We checked these texts against the holdings of the open ITI repository that I just mentioned. So if we just zoom in on one of these 5 subcorpora, the Hanafis, and I'm now tilting it. What you see here horizontally is now, this is what I'm now showing you in a vertical column. These are the works that went into the corpus. So many of these texts are quite well known, others perhaps less so. But we had to make some compromises because not all of the famous works are digitized, for example. So you have to deal with what is there digitally available. Another problem with this kind of selective corpus is that, of course, and I'm already kind of implying it, the Hanafi tradition is not just one line. It is really a jungle of texts with many different lines that crisscross, many commentaries, super commentaries. So here I've tried to give an impression of this fact that, Ibn Abidin, for example, very well-known 19th century Hanafi text, is really a Hashi on al-Haskafi, who himself wrote a sharh of At-Tumurtashi, who wrote a sharh on Ibn al-Humam's Fath, which itself connects back to Al-Marghinani's Hidayah, and so on and so forth. So, by only looking at this, you don't really catch this complexity. So what we have still is a very simplified corpus, is I guess what I want to say. Now, 2 more problems. Another problem in building such a corpus of text and then analyzing it is that if you want to do sophisticated analyses, you would really like to have a powerful machine that helps you to recognize, identify not only words, but also roots of Arabic terms. The problem is that the word recognition in Arabic digital texts remains problematic, and this applies not only to Islamic law, obviously, but to all kinds of Arabic literature. So you have to develop, or to illustrate this, let me show you this. So if you want to do something, you want to work on the concept of maslaha in Islamic law. Now, the word maslaha, if you know Arabic, can appear in many different shapes and guises. Al-maslaha, wal-maslaha, fa-maslaha, etc., bi-maslahatikum, you name it. So there are all kinds of prefixes and suffixes that can enter into the equation. So, for example, you can get this, fa-maslahatakum. This unbroken chain of letters is called a token in computational languages. Now, you recognize, because you know Arabic, you recognize that there's the word maslaha in this token, and also in all the other combinations. But for the computer, different tokens are completely different entities. Meaning that if you search for maslaha, only for maslaha, you will only capture a small fraction of relevant mentions. So you have to tell the computer that he should add all possible permutations and combinations up for the purpose of analysis. And you also want to capture the plural, masalih, perhaps also the adjective aslah, and so on. So the possibilities multiply quickly. So the answer to this, you might say, is okay, we don't look for maslaha, we look for roots, for sad, lam, ha. That is problematic, however, because automatic root recognition is not working very well. Even if companies who sell tools for root recognition will claim the opposite. And most digital online repositories, such as Al-Maktaba Shamila, don't even offer the ability to search for roots. Also, root recognition tools, what we call stemmers, are often commercial, and none of them, or almost all of them, are not open code. So if you cannot read the underlying computational code to understand how the recognition algorithm works. Plus, even if you restrict it to the root, your search to root letters, you get false hits. You get sulh, for example, peace. You get mustalah, which means technical term. You get salih, pious and godly, and so on and so forth. So all these are terms that you might actually come across in the text of Furu al-Fiqh, but not terms that are directly related to the legal concept of maslaha, which of course means the common good. So after experimenting and digging into this, we kind of decided to leave root recognition behind and instead try to do more with smart searches of words, Boolean searches. Now, there's again the problem that many online platforms don't really allow you to do smart searches. So I'm talking about adding an asterisk in front or at the end so that you capture those things. If online repositories or the available tools allow it, then they will be very, very slow often, really annoyingly slow, and that will hinder your research significantly. So in the end, we decided, okay, unfortunately, we have to build our own research engine. And this is what it looks like. It's called Black Lab Arabic or Black Lab ADH, Arabic Digital Humanities. I put the link on the slide. You can look it up for yourself. It is a search engine that was actually developed for a different language, for Dutch, by Dutch linguists a while ago. We adapted the search engine to make it compatible with Arabic. So now you can enter Arabic words in it. And it looks like this, as I said. Now, if you zoom in on the search function, which you see here on the left, if you zoom in, you see that you can do these combined complex smart searches, maslaha with an asterisk in front and the back, and then you can even amplify or enlarge the search to also include instances of masalih and aslah. So that way, for hopefully you will not hit on salih or sulh when you search for the term. Okay, so this is the first part of my talk. I just wanted to show you, the kind of raw material that we worked with, and Black Lab ADH. It really helps you to measure frequencies of terms or clusters of terms in a pretty efficient way. It also allows you to search for roots. There is a search, you see here root on the slide. There's a root extraction tool, but actually we advise you not to use it too much because of the problems that I mentioned. Additionally, what is also useful is that you can filter results according to school of law. So you can say, give me results, but only for the Hanafis. Or according to the centuries, you can tell the tool, give me results, but only for the 12th and the 13th century, or even region of in the Islamic world. So you can tell the tool, give me results, but only for the Maghrib or only for Iraq. Now I'll show you some of the results, and I'm aware of time being short. I have to be quite quick. I have another 5 minutes or so. It's already. What do you say, Zezin?
Yeah. You still have time, Pak.
Okay.
Yeah.
So, to begin with something that many of you will know, word clouds. It's a very simple way of, a statistical analysis of a corpus. So here you see the word cloud of the entire corpus that we built. The bigger the word, the more prominent it is used in the corpus. So you see, this gives you quite a nice impression of what Islamic law is about. As-salat is the most important topic, followed by al-mal. So, the law of ibadat and prayer in particular is very central, but also commercial law. Al-bay also figures, Muhammad is there, the prophet, and so on and so forth. Now, there's another type of word cloud that you can build. It's called parsimonious word cloud. You can ask the computer, okay, give me this kind of word cloud, but give it to me only for the Hanbali subcorpus, And then please make words bigger that the Hanbalis use often, but the other schools don't use so often. So it highlights words that are specific and special about the Hanbalis. So here's the result of this so-called parsimonious word cloud. Ahmad is big because the Hanbalis refer to Ahmad ibn Hanbal a lot, whereas the other 4 schools in the corpus don't. Al-Khiraqi, interestingly also. Wa'anhu, you see also as a very typical phrase used apparently in the Hanbali corpus, which probably also refers to Ahmad. You know, they often say wa'anhu, and they mean that an opinion comes from Ahmad. So this gives you nice snapshots, but it's not very deep, analytically speaking, perhaps. We tried to do some an analysis of, you know, more technical, specific technical legal terminology, starting with haram and halal, maybe the most basic terms that we have in the corpus. And here we show how the use of haram in comparison to halal maps out onto the five legal schools. So you see in a nutshell that the Jafaris have a tendency to speak about haram in 7.7 out of 10 cases and about halal in 2.3 of 10 cases. And the ratio is somewhat more forgiving for the Hanafis. So the Hanafis are one end of the spectrum. They seem to be not as much focused on haram and halal as the Jafaris. But you realize the margin is quite small. So you could also argue, oh, well, this is statistically irrelevant. But remember that the corpus we're looking at is really quite big. So maybe even the small differences tell us something. Here you see the spread or the ratio of haram and halal and how it develops over the centuries for all the schools. You see, or this suggests that in the early legal texts, there's roughly the same amount of attention given to haram and to halal, and then over the 4th and the 5th and the 6th centuries, you know, the texts seem to be talking about haram issues more and more, and then it plateaus somewhere in the 7th century and continues until the 19th century. Here you see the ahkam, the 5 ahkam. Again, you know, remember that we're using here these complex Boolean searches, hence the asterisks and also the pluses, which I can't explain in detail. But if you look up the paper that we published, there's a more elaborate explanation of how it works. So this slide shows you that there's a whole lot of attention, obviously, on the things that are wajib and haram, much more on wajib than on haram, interestingly. And that the middle categories, and you know, the ethical categories of Islamic law, which don't result actually in a legal prohibition or a legal command, they tend to be, you know, quite small, maybe a quarter, maybe less. And you often hear people talk about Sharia being more than just a legal code, also being a way of life, an all-comprehensive system of normativity, where a lot is said about the things that you should do or that you better not do. That is true, of course, but you know, of course, the jurists in the Furu al-Fiqh corpus will focus on the things that are really legally relevant, in the sense of, you know, resulting in prohibitions or commands in haram or wajib statements. So it sheds an interesting light, I think, on these claims by certain people that, you know, Sharia, you know, is as much ethics as it is law. This seems to suggest that it is, you know, mostly law and not ethics. Okay, well, I'm wrapping up. You can do the same exercise for the schools and compare them. Again, the differences, you might say, are not so great statistically speaking, but it says something maybe that the Hanbalis seem to be talking slightly more about wajib than, for example, the Malikis. But the interpretation of this is still something you have to do as a scholar, and the computer can't help you with that, really. It can only give you numbers. Final thing I want to talk about is the footprinter. Now, this is another program that one of the members in our team built. It's a program that allows you to locate the Quran in this corpus of Furu' al-Fiqh. So we're still talking about the same corpus of 55 legal texts. We wanted a tool that would help us locate the places in these texts where a certain Quran verse is mentioned, and also that would help us to learn something about how often is this Quran verse cited, etc. So what you see here is the squares, the blue, red, and orange squares, and there's also the other colors, light green and dark green. These represent the 5. So one color is one of the 5 schools, one square is one work. The yellow dots are the Quran verses. So you see that a square will have a line that connects to a dot. That means that a work cites a particular Quran verse. If you put this in one visual, you get this, a mega network of 55 legal works of Furu' al-Fiqh with all the Quran verses. Now, this in itself is only an overview. It doesn't help you, but you can zoom in. You see there's a plus and a minus, so you can zoom in. And then, the deeper you zoom in, the more you see. So here you see the titles of the works. Then you can zoom in on individual works. This is the center of the thing, deeper. And if you go to the deepest level, you can also see the Quran verse and the surah number and the ayah number. One thing that is interesting, if I go back here to the beginning, you see that there are some islands on the periphery of this network. One thing that I haven't mentioned yet, but which is common to network visualization. So if an item is connected to several of the works, if a Quran verse in this case is connected to several of the legal works, it will tend to appear in the middle of the graph. If a verse is mentioned in only one work, it will be on the periphery, on the margin. So you see these islands. These are Quran verses that are mentioned, cited by only one work of Furu' al-Fiqh. So if you have a very big island, it's interesting because that would suggest that this one legal work has a tendency to cite a lot of Quranic material that the other works don't mention. So here's another interesting aspect. Here is, you can also zoom in on single works. So you see Al-Hawi Al-Kabir here of Al-Mawardi Shafi'i work. And then follow up. You can click on the Quran verses and it will allow you then to read the place in the text where the Quran verse is cited. Very sorry, I'm really going over time here, but I wanted to show you at least some results. Here is the average frequency with which the madhahib quote the Quran. And this is very rough. This is a bit rough, but you see that the Shafi'is quotes the Quran at roughly every 982 tokens. This is in a printed edition, roughly every 5 pages. And the frequency is slightly different for the other schools. The Malikis are, interestingly, and this was surprising to me, I didn't expect it, are the school that seem to quote the Quran the least. One possible explanation is that they are very much wedded to the opinions of Malik ibn Anas and the Muwatta, where they are recorded, that they have a tendency to refer to Malik maybe as much as to the Quran. I think this is the last slide. Here you see the top 5 Quran verses cited in the corpus, the top 5 most frequently, most often quoted verses in Furu' al-Fiqh literature in our corpus. Quran 5:6, the ablution verse is quoted most often, it seems, to 196, Hajj and exceptions to Hajj, and so on. You can follow on these results and read more about them in the paper that I mentioned in the beginning. So I'll come to my conclusions. First of all, I talked about problems. There's the problem of the unreliability of word and root extraction tools. So we have to be very careful about claims about the accuracy of these tools. There's also the problem of the possible biases of the digital corpus as we have it now. Al-Maktaba, I talked about Al-Maktaba Shamila. And then I showed you that the computer can do certain things, but it can't do everything. 3 computer can do, it can certainly accelerate research. Now you can tell a student, for example, who's interested in a particular Quran verse, oh, go to this tool, Quran Footprinter, and bam, in 1 second, you know where the Quran verse is mentioned in the literature. And maybe it will even show you places that you didn't expect. It can trigger certain questions. So, the thing about, the Hanbalis seem to be talking about wajib more than the Malikis. Why is that? We don't have the answer through the computer, but the computer triggers a certain question. And maybe, and this is as far as I will go, the computer can perhaps confirm or undermine certain scholarly intuitions. There's a scholarly intuition that is quite vague, for example, that the Hanafis are a bit more permissive than the other legal schools. They, tend to allow more, not to be so strict maybe than the Hanbalis and other schools, or the Jafaris. Well, if you look at these ratios that I showed you between halal and haram, it tends to confirm this. So, maybe the computer can generate some supporting arguments. And I'll stop here because this is all I wanted to say. And again, sorry for talking for almost 30 minutes. Terima kasih. And hopefully we have a couple of minutes at least for questions.
Thank you so much, Pak Christian, for your presentations. I think participants here, there's a lot of questions for your presentation. So without further ado, I would like to give the opportunity for the participant to give questions to Professor Lange. But since I'm not in Lombok, so I would like to need to ask some help from, I think, moderators or someone else in Lombok who can manage the circulations of the event.
I'm here, Kang Jezen.
Yes, please, if you have questions, I have one in the chat room, but I would like to give opportunity first for those who are attending in Lombok.
Yeah, we have one question in the chat box, but we have one participant wants to ask question here.
Yes, please.
So we hear the one from Ibu Masrofa.
Okay, thank you so much, Professor Christian Lange and Dr. Zezen Mutakin as a moderator. That was a very interesting topic, Professor, and this is very new from us because it can be eye-opening because this is a very project from you, and it will give some insight for us. Okay, I'm Masrofa from Sharia and Law Faculty. I would like to ask you questions. Based on your presentation today, it's all about Islamic legal academia. We are here, and you told me about the historical of classical resources. Is that right? And so I would like to ask about what about the contemporary resources, like available online or something like that? Because you told us about kind of a historical classical resources. And what about the contemporary resources? And the second one is there any basic requirement? Because this is very new from us, because most of us are legal expert. And so what is exactly the basic requirement to enter this area? Should we become an IT expert or just legal expert? Or we are, as the legal expert, we can use the IT expert to do some research like you did. Okay. And then would you like to figure out about this? Thank you so much.
Thank you, Dr. Mashrufa, if I understood correctly. Do you want me to answer or
I think so, yeah.
Yeah?
Yes.
Okay. Well, thank you for your kind question, Dr. Mashrufa. The contemporary resources, yeah, you're quite right. You notice that our corpus stopped at the 19th century, huh? So we don't include the 20th or even the 21st century. Simply, I think, because the online repositories also tend to stop around the time of Ibn Abidin in the 19th century. They don't really include a lot of works of contemporary or modern scholars. Perhaps, one or two Azharis from the 20th century will be included, but the texts are not really available and also not digitally available. So this would require, I think, another project. And I would say that you would have to have quite a bit of money and manpower or woman power to also digitize texts of the 20th century authors, but it is possible. So imagine you have a big team of yourself and colleagues, and the ministry wants to throw money at you. You can hire people to, first of all, digitize the text. That is basically typing the texts into a digitized format, or maybe you can get the digitized file, and then you can add a corpus of the 19th or the 20th century, or let's say the 20th century, to, for example, the existing corpus on GitHub, the Open Text Initiative. So that hasn't been done yet, but it can be done. Another important area and dimension would be to look at the online legal discussions that are going on. So you're all very familiar, I'm sure, with online fatwa sites. There could be a beautiful project on single sites or maybe several sites collecting the fatwas from the site into a digital corpus. There's a technique known as scraping texts from the internet. Maybe you've heard this term before, scraping texts. So it requires a bit of expertise. I think you will need maybe even need an engineer, computational engineer, to do it for you. Some people are very good with their computing skills, so maybe you can do it yourself. I don't know. Scrap these texts from these online fora, build a corpus, and then run these analyses. Again, I don't think it's been done. I know single studies have been done of online fatwa collections, but they're not done computationally. I think they are done, the old way. You read them, maybe you do a bit of manual statistics. But that would be very interesting. The other question is about basic requirements. Very basic. The most basic requirement is the ability to type in Arabic. But if you're a scholar of Islamic law, hopefully you'll be able to do it. That will allow you to go into, for example, Arabic Black Lab, what I showed you, or the Footprinter, and do your own searches. That's the most basic requirement. So if you don't know how to type, I'm talking not really more talking about to students now, I think, than to researchers. But if there are students in the audience, make sure you know how to type in Arabic on your computer and how to switch back and forth, etc. The next level, I think, would be to teach yourself the basics. If you have built a corpus, say you have scraped texts from the internet, online fatwa, you have built your own beautiful corpus of, online fatwa from 5 different websites in the period from 1980 to 2000 on marital law, to connect to the previous talk. Say you have built this corpus. If you want to analyze it yourself, you have to have basic knowledge of languages, computational languages. There are online tutorials that you can follow, for example, on languages such as R, it's just a big capital letter R, or Python. I think these are the two most used computer languages that it is possible to a certain extent to teach yourself. There are YouTube tutorials that you can follow. You have to realize it's a bit like a language, so you have to put in an effort. But I think, I'm being optimistic, but if you put in 20, 40 hours of work teaching yourself the basics of Python or of R, you could run easy searches and easy analysis on your own corpus. So I'm saying the message I want to get across is, get your hands dirty, do it, try it, but also don't waste your career on this, because it can be very, very time consuming. Just to give you one impression, then I'll stop. The paper that I mentioned that was published on the basis of the research that we did in Utrecht, it's one paper in a very good journal. It's Islamic Law and Society, so we're very proud of it. But there were 5 people working on this paper over a period of 2.5 years. 5 people working on one single paper over a period of 2.5 years. Now, you can calculate the effort and whether it's worth it or not. So we're still in the early stages. Hopefully in a couple of years, or in 10 or 20 years, people will be much more at ease with computational methods, and it can be done quicker, but it costs us a lot of effort and time. And I wouldn't advise junior students to do it necessarily, because you have to publish and get your book out, etc. So, a word of caution.
Thank you, Pak. Just for your information, actually, all the resources that Professor Christian Lange mentioned in his paper actually available publicly through the website, like the Black Lab and Quran Proofing. We can access it actually through through their website to try ourselves to learn about the method of computational method to research on Islamic law. The second question is on chat room, is from Nando. I would like to read it for you, Professor Lange, and then you may respond it. How to develop Islamic research or studies as proposed by Islamic thinkers. So far in Islamic studies, there are still many who only use one approach in studying Islam, like normative and theological approach, so that Islam is only interpreted in terms of concept of God, saying something only as a command of God, has nothing to do with human life in this world. How can digitalization develop its own legal knowledge? I don't know. I hope you understand the questions.
Yeah, it's an interesting issue that is raised by Nandu. Thank you. I think that digital methods are not in a totally different way of doing research. It's not so. If you talk about normative theological approach, historical, Islamic studies approach, the digital approach is not something apart. It's not a new, different third way of doing it. It can support both the theological normative, but also the more historical Islamic studies approach. So I don't see that the digital method is, for example, in conflict with a theological or normative approach. I mean, it's all about your interpretation, as I said, right? The computer will only give you the numbers, and then whether you're a theologian, someone committed to a very strong belief that Sharia is this or that, or whether you are a historian like myself, I only study it historically, you can do something with it. So but it's not going to solve our problem of theologians talking to historians and sometimes not talking about the same thing, unfortunately. No.
Thank you. Any more questions from the floor, Ibu Windy? Or one more question, Pak Christian? Yes, please. But we could not hear your voice.
Can't hear you, yeah.
No voice, no voice.
Okay.
Yeah, good.
I personally very interested in what you said. You said that this is a very costly project. If you mention that it is expensive, how expensive it is? Very expensive, little expensive? And I believe it's worth doing. Doing digitalization is something can be useful, but I know Sharia source, and what is the difference between your project and the Sharia source, and is this something that is happening around the world? Like Islamic legal scholars try to approach their area in digital way, and in your knowledge, how many projects similar to this project? Thank you, Pak Christian.
Yes, thank you for the question. How costly is it? Yeah, I think most of us are not trained as computer experts, right? So we need to pay someone to do the computational work for us. And as I said, I think the analysis is so difficult and so experimental and tentative that you have to calculate that it will take a bit more time before you actually have enough courage to publish the results. So this is just my own experience. The research takes 3 or 4 times as long as the normal research we do, and you always have to have someone by your side who's holding your hand and who really knows the computer side of things. So, and you have to pay that person. So that's the cost. It's your own salary and the person that is helping you with it. Now, for the other question, yes, I also know Sharia source at Harvard. I think the difference so far has been that they mainly collect and build a repository, and they don't really offer tools to analyze the repository yet. But the person who was really the leading computer scientist on my project in Utrecht has now been hired by Sharia Source. His name is Yusuf Çelik. He's a really a very, very good computer scientist and someone who has studied Islamic studies.
Oh,
so he is a person to watch. I think he will also help Sharia Source to become more analytical. And Sharia Source, you're absolutely right, is not the only other project that there is. There are other initiatives in the area of Islamic law. I know of maybe 2 or 3 or 4 other single researchers who are trying to do things, but they don't have the luxury of having a computer engineer at their side. So they've been trying for a long time to teach them themselves, and they haven't published them much, unfortunately. So you really have to look at projects, at teams of people doing things. So there was the Utrecht project, it's still going on, but I think we are more or less finishing it now. There's Sharia Source. There is the Kitab project in London, very important. Kitab project, London. But they don't, so far, they haven't looked at a lot of legal literature. They're mostly about chronicles, history. And then is it Qatar? Well, there's one big project in the Gulf. I think it's at Qatar University, where there's also a research master program of digital humanities. Also, things seem to be going on. This is what I know. Maybe there's more going on in Iran. I wouldn't be surprised if in Iran people are doing this kind of research, and maybe even further east. But I'm not sure. And maybe also in other Arab countries, but this is the extent of my knowledge, and my knowledge is very limited. Thank you.
The challenge is for UIN Jakarta to create the same thing, Mbak Windy, at least for Indonesian context to become the center of data for Islamic law.
Yeah, I mean,
Hukum online, because so far is by Hukum Online, which is a small PSHK group somewhere in Kuningan, not by Islamic State University. Maybe that the challenge for us to create something like this, modestly in the beginning, just in Indonesian context, probably, and then to Southeast Asia, and then who knows?
Yes, no, I totally agree. And yeah, Dr. Mashrufa was talking about this, how to make this, carry this into the 20th century. I think in Indonesia, and I remember from the conference that I was lucky enough to attend in Jakarta and also in Depok, there were lots of talks about online legal discussions in Indonesia today.
Yeah.
And these are fantastic resources that you, as I said, scraping, if you manage to scrape these texts, perhaps even non-verbal sources, videos, and so on. If you collect them if you create big data and then have the ability to run analysis, that could be very, very interesting. And I'm sure there must be people in the Indonesian government who would find this very interesting and give some money to pay the computer scientists. Yeah.
I think we have to give applause to Professor Christian Lange onlinely and lively in Lombok. Have you been to Lombok, Pak Christian?
No, unfortunately not.
Lombok is very beautiful island like Bali, so maybe inshallah one day you will visit in person.
Inshallah,
to Lombok.
indeed, yeah. So terima kasih again, and I hope you have a very fruitful conference, and I hope to see you again.
Thank you so much, Pak. Windy, I would like to give the floor to you again. Thank you so much, Pak Christian, and thank you so much for everyone in the conference room and in online room. I would like to close by Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, Kang Zezen. Thank you, Pak Christian. Wish to have you in the next conference again. Thank you, terima kasih. Bapak dan Ibu semua, kita setelah ini akan ada sesi lagi. Kita menunggu pengumuman. Kang Zezen, ada mahasiswanya di sini.
Ya. Oke, terima kasih banyak ya Bapak Ibu
Terima
sekalian.
kasih ya Kang Zezen.
Sami-sami.
Nuhun.
Ya, assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh. Setelah ini kita akan ada sesi online bagi presenter online, tapi untuk yang offline kita akan mulai kembali nanti malam. Jam 7 malam akan ada jam 7.30 maaf. Jam 7 kita sesuaikan jadwal. Jam 7 akan ada Profesor Asep Saifuddin Jahar yang akan berbicara dengan kita semua itu jam 7. Jadi Bapak Ibu kembali lagi ke ruangan ini pada pukul 7. Kemudian dilanjutkan dengan parallel session yang offline di sini. Jadi sore ini hanya akan ada yang online. Jadi Bapak dan Ibu dipersilahkan untuk istirahat. Terima kasih atas perhatiannya. Kita tutup dengan hamdalah. Alhamdulillahirabbil alamin. Assalamualaikum warahmatullahi wabarakatuh.
Insyaallah.
Tinggal keuangan doang kan?
Bapak Ibu langsung aja ngomong di situ.
Pak Jayusman.
Iya, Mbak.